আপনি না বহাল না তাই স্কুলে যাবে তাই স্কুলে যাবে তেনো স্কুলে যাবে তাই মাটি রে না ওটা থেকে ঠিক পছলা দেখতে দাও
Previous Lordship, I picked to mention edition item number 3 to 7. I repeat that I may be granted 4 weeks time. The Lordship, I have received the counter file by the state respondents. 3 to 7.
You are for the petitioner.
Yes, Lordship.
Oh, the state has filed affidavit on opposition.
Yes, by the state respondents.
When was it filed?
Your Lordship, 2 months back, Your Lordship.
2 months.
Yes. Recently, in item number 6, I have received last month only, Your Lordship.
Okay, 6 also they have filed affidavit.
Yes, Lordship. And all the writ petitions.
Okay. You want to file rejoinder?
I want 4 weeks time, Your Lordship.
For rejoinder?
Yes.
22 matter, 3 weeks. On a prayer, the learned counsel for the petitioner has submitted that rejoinder affidavit would be filed, for which he has prayed for and is granted 3 weeks time. List after 3 weeks. Petitioners, petitioners. Petitioners. 3 to 3 to
7.
Okay.
Please, my lord. Lordship, I beg to mention hearing item 17 and 18, Lordship. I have a fixed matter in court 3, Lordship, which I don't think I can adjourn anymore, which is why if it can be fixed on Tuesday, Lordship, coming Tuesday.
17 and 18?
Yes, my lord.
Okay, we'll have it on next Tuesday.
My lord.
On
Tuesday.
a prayer made on behalf of the petitioner, list these matters for hearing on Tuesday next date.
Deeply obliged.
May it please your lordship. My lord, I would like to mention here in item number 12.
12 years.
Lordship, I am here to file additional affidavit here, so kindly grant me 2 weeks time, lordship.
Additional affidavit for what? I think this is a matter of 2019.
Yes, lordship. Although in the last occasion, lordship, I've prayed before this honorable court to file the additional affidavit and the court's permits.
Let it reach 19 matter for additional affidavit. We are not adjourning. Let it reach. We'll see at the time when the matter is called up. Yes.
Lordship, then in that case, let this matter release that after 2 weeks, lordship.
We are not adjourning 19 matter. Let it reach. If there's a reason for adjourning, we'll adjourn, otherwise not.
Lordship, then I beg to mention item number 1, lordship. Here I'm here to file affidavit in opposition. Kindly grant me 2 weeks time, lordship. I'm for the respondent number 4.
Okay, on 7/5/2024, you were granted time to file affidavit. Why haven't you filed? Okay, we grant you 3 weeks further time. File it.
Lordship.
On a prayer made by the learned counsel for the respondent number 4. Matter is adjourned by a further period of 3 weeks to enable filing of affidavit in opposition.
Mashallah.
May I please, Your Lordship. Lordship, I beg to mention hearing item number 21.
Yes.
Yesterday, we have also submitted our adjournment memo, Lordship.
Okay.
Today, my senior has some personal difficulties.
Okay.
So I pray the matter may be listed after 2 weeks, Your Lordship.
What is the matter about?
Lordship, they are challenging the order passed by the Lokayukta, Lordship.
Lokayukta. Okay, we can have it next week.
Lordship, if it's convenient for the
Next week,
petitioner.
we'll see next week,
So,
next
Lordship,
Tuesday.
after 2 weeks,
Oh, next Tuesday, let us try.
after a week, Lordship.
Yeah, after a week, next Tuesday.
Lordship,
A prayer for adjournment has been made on behalf of the petitioner.
respondent,
Respond number
respondent number 4.
4. List next Tuesday. for
Lordship,
hearing.
interim order may be continued.
Interim order passed out to continue till the next date of listing.
Obliged, Lordship.
Yes.
My lord, in item number 1, also there is an interim order.
Okay, one interim order passed to continue till the next date of listing. You did this one, two. 1, 2, did this one. Did the Mr. Council, since there is an interim order, we'll give a fixed date. Okay. We had granted 3 weeks time. We'll have a date after 3 weeks. List on these. Today's 21st, I think. 1, 2, 3. We'll have it on 12th of January, 13th of June. 13th of June.
Please, Your Lordship.
Yes.
Lordship, I beg to mention item number 10, Lordship.
Yes.
On behalf of Ajung Lee, Lordship. I'm yet to receive instructions, so kindly grant me 3 weeks time, Lordship.
Lordship,
You're for the respondent.
Lordship.
Yes.
No, please, Lordship, this matter is pertinent to appointment on compassionate ground.
Okay.
Lordship, it's a simple case, so 1 week time may be given, Lordship.
The new matter, 2024 matter.
Lordship,
1 week may not be enough. When was notice issued? Recently, only in March, I think.
25,
Yes. We grant you 3 weeks time, but file it.
Lordship.
We'll have a date. He's saying it's a matter, simple matter.
Lordship.
Yeah, for the respondent,
For the state response, Lordship.
the learned counsel for the state has prayed for time to enable filing of counter affidavit, full stop. The learned counsel for the petitioner has, however, informed that this matter pertains to appointment on compassionate ground, and accordingly the matter should be taken up expeditiously. Full stop. List on, we give a date. List on 14th of June,
Lordship,
14/6. Madam, you file it before that.
Lordship.
Okay.
obliged, Lord.
My pleasure, Lordship. Lordship, I beg to mention item number 8.
8, yes, please.
I'm going to receive instructions, so kindly grant me 3 weeks time to file the affidavit.
Government.
Lordship.
Okay. Yes,
No objection, Lordship.
3 weeks on the prayer made on government, 3 weeks for filing rejoinder affidavit.
Lordship, I'm going to receive my instruction.
To receive the instructions, let's file affidavit in opposition. Get the instructions, file the affidavit.
Lordship. I will pledge.
May I please, Your Lordship, I beg to mention item number 22.
22, yes, please.
Kindly list this matter next week since my seniors in this post.
22. Your senior has got some problem today.
Yes, Lordship.
Okay, inform the other side.
Yes, Lordship.
Okay, we'll have it next week. 23 matter, next Thursday. On a prayer made on behalf of the petitioner. List next Thursday.
For motion, item number 23.
May I please, Lordship? Lordship, I'm challenging the appointment order of respondent number 3. He was appointed.
Appointment is of 18/7/2023.
Lordship.
Why are you so late in coming for an appointment? You can challenge, but you are also having an interim prayer. After almost a year, how can you pass an interim order? Will issue notice here? You claim to be a descendant of a landowner family.
Yes, Lordship.
Okay.
Yes.
Heard, heard, Ms. Swinson, and counsel for the petitioner. Full stop. It is the case of the petitioner that the claim of the petitioner is towards appointment on the ground of the land donor. Full stop. It is, the petitioner has also challenged an order dated 18/7/2023 by which the respondent number 3 has been appointed as MTS.
Lordship.
Full stop. That notice of motion be issued, returnable by 4 weeks. That steps be taken for service of notice. Oh, no, you will be taking upon whom? 1 and 2.
1 and 2, Lordship.
You are the state council.
Lordship.
Ms. Swinson, state council accept notice on behalf of 1 and 2. Extra copies during the course of the day. Steps for service of notice upon the respondent 3 by registered post with AD. Steps by tomorrow.
Lordship.
For motion, item number 24.
May it please my lord. Lordship, I have a very limited prayer
Yes, sir.
by filing the instant.
Disposal of the representation.
My lord, my
But
lord.
you tell us one thing. See, the original incumbent had passed away in 2016.
Yes, Lordship.
His wife had passed away in 2020.
Yes, Lordship.
Till her lifetime, she was getting the family pension.
Yes, Lordship.
Now your claim is for the son.
Yes, Lordship.
Son is a minor.
Yes, Lordship.
The rules contemplate that minor sons should also be
Yes,
getting the
Lordship.
family pension
Yes, till 25 years of age.
till 25 years
Yes,
of age.
Lordship.
What is the age of the son?
9 years.
9 years. And
Yes.
you are the grandfather of.
Yes, Lordship.
Madam,
Here, the Deputy Commissioner is not implemented and he's a necessary party here, Your Lordship. The Deputy Commissioner Longland.
okay, who will take the decision? Deputy Commissioner?
Your Lordship, since there's, if you may turn
Yes,
to
Lordship.
page
Lordship,
33 of
yes.
the,
The
Writ
learned
petition,
government
Your
council is
Lordship.
right, Lordship. Therefore, I may be allowed to withdraw and impeach him and refile again.
Why do you withdraw, file an IA?
and Your Lordship,
You get the Deputy Commissioner included, then we can ask her to seek instructions and dispose on the next day.
My
Your
lord, my lord. my
Lordship,
lord.
even the Treasury Officer Longland will be necessary, Lordship. Treasury Officer Longland District, Your Lordship. Both of them have not been implemented, Your Lordship.
No, see, the reason which he has cited here
Yes, Your
is
Lordship.
that the name of the minor son was perhaps not included in the pension papers.
Lordship.
So that is the reason. For that, the issuing, the pension releasing authority may not be a necessary party. It is okay if he's in the area of proper party.
The PPO books, the Treasury Officer has is the custodian of the PPO
Okay,
books. so that
corrections
is it.
may be needed at
Yes,
the
Your
other
Lordship.
stage. Okay,
Yes,
so
Lordship.
you do one thing, then you file afresh.
My lord, my lord.
Let it, counsel for the petition, so let it counsel for the petition submits that there are certain formal defects
My lord.
regarding arraying of parties. Full stop. Ms. Swinson, State Council has in fact, has also submitted that in absence of those parties, a fair adjudication may not be possible. Full stop. Learned counsel for the petition accordingly prays to withdraw this petition with a liberty to file afresh. Full stop. Petition is accordingly dismissed on withdrawal with liberty as paid for.
Deeply obliged.
Item number 25.
May I please, Your Lordship. Lordship, in the instant petition, Your Lordship, the petitioner is.
You're
praying
working for 30 years
Lordship, already 32 years, Your
as
Lordship,
Jugali
as Jugali, works as Jugali. Your
in
Lordship.
the CAWD.
Yes, Your Lordship.
Okay. Madam, we issue notice. You will accept for all the respondents?
Lordship.
Heard, so and so. Learned counsel for the petitioner who has made a prayer, who has made a claim for regularization of his service owing to the fact of serving for about 32 years
Lordship.
in the CAWD, full stop, comma, Nagaland. Full stop. Let notice of motion be issued, returnable by 4 weeks. Mr. London State Council accepts notice on behalf of all the respondents.
Lordship.
Let extra copies of the petition be served upon her during the course of the day.
Item number 26.
26.
Lordship, Your Lordship, the matter can be passed over for the day, Your Lordship. Your Lordship, here the leading counsel, Your Lordship, is indisposed of, Your Lordship. If the matter can come up on Monday, Your Lordship.
Next Monday, madam? On a prayer for adjournment has been made on behalf of the petitioner. Full stop. List for motion on Monday next date.
Lordship.
For hearing, item number 27.
No, we finish off the
For
admission.
admission, item number 2.
It is, Your Lordship. Your Lordship, if the matter can come up on Monday, Your Lordship.
You have not filed your rejoinder.
Yes, Your Lordship.
You file your rejoinder.
Lordship.
Will you be able to file the rejoinder by Monday?
Lordship, within, on Thursday, Your Lordship. The matter can come up on Thursday will be.
No,
fine.
no. Will you be able to file your rejoinder within Thursday or Monday?
Lordship, Lordship.
You will.
Lordship.
We'll have it on Monday then. File it. Okay. Thursday is only day after tomorrow. Take your time.
Your
Further
Lordship,
time,
next Thursday, Your Lordship.
Next
Next
Monday.
Thursday. Next Thursday,
next Thursday.
Lordship.
Further time till so, next Thursday is granted to enable filing of rejoinder affidavit. Okay,
Lordship.
list accordingly.
For admission, item number 7.
Well, please, Your Lordship. Your Lordship, this item number 7 has already been mentioned, Your Lordship.
7 has not been mentioned.
Along with 3, 4, 5, 6, and 7.
No, 7 is not connected. 7 is a different, they have wrongly said 3 to 7. It should be 3 to 6. 7 is not connected.
Yes, Your Lordship. But here, the state has already filed, so.
No, they were given time to file rejoinder affidavit.
Yes, Your
They
Lordship.
have they filed.
No, Your Lordship. The petitioner's counsel had earlier sought time with regard to this item as well, Your
That
Lordship.
we have seen.
Yes, Your
There is an
Lordship.
order of 23/4/2024.
Your Lordship, if it may be listed after some time, I'll inform the petitioner, Your Lordship.
Yes, please do.
Yes, Your Lordship.
We'll like to pass orders in his presence
Yes, Your Lordship.
after a while. No?
Item number 9.
Yes, Your Lordship.
Yes.
The present petitioner was appointed as Constable Taylor on 1/9/1994 as under the establishment of 5th NAP Battalion in the name of Zani Sol Angami.
Have filed your
Right.
affidavit or not?
What?
Have you
Sorry?
filed affidavit?
No, my,
Will you like to file affidavit or not?
my lord, here, there is a serious issue.
Okay.
Initially, he was appointed as Zani Sol Angami, but after serving for more than 8 years, he applied for change of name from the present Zani Sol Angami to Annexure 1, Your Lordship. Type copy, page 8, in the form of affidavit. I, Shri Zani Sol Angami, son of Divol Angami, Chumukidima Block 3, District Dimapur State, Nagaland, do hereby solemnly affirm and declare before the magistrate that my actual name and address is Mr. M. Pirma Birmani Singh, son of
You're reading which page? Page?
page 8, Your Lordship, of my state affidavit in opposition.
Of course, state affidavit. Okay.
Yes, my lord. I filed on 9 February 2024.
Yes, please read.
Running page 8, Your Lordship.
Yes, yes.
Affidavit, I, Shri Zanisol Angani, son of Dival Angani, Chumagidima Block 3, District Dimapur, State Nagaland, do hereby solemnly affirm and declare before the magistrate that my actual name and address is Mr. M. Birmani Singh, son of late N. Krishna Mohan Singh, village Walarbon, PS Banskadi District, Silchar State, Assam. Henceforth, I will be known as M. Birmani Singh, son of late N. Krishna Nani Singh, and this name will be used for all correspondence concerning to personal/official matters. My lord, here, while the petitioner was serving as such, on attaining superannuation of age, he retired from service, and he had processed for pension. However, objection has been raised by AG, that is my annexure 3, page 7, Your Lordship, of my affidavit in opposition, Your Lordship.
Page 7. Page?
Page 10, my lord.
Annexure 4.
Annexure
Annexure 3.
3, yes,
Okay.
my lord.
Yes.
May I read, Your Lordship?
Please.
Office of the Accountant General, A&E, Kohima, Nagaland, to the Director General of Police, Nagaland, Kohima. Subject pension case in respect of Mr. Shri M. Pinani Singh, retired constable under the establishment of 5th NAB Battalion, Nagaland PAC. Sir, in inviting a reference to your letter number such and such, dated such and such, I am to return the following documents with the observations mentioned below. Number 1, on checking the service book, it is found that the service book belongs to Shri Zanisol Angami. Hence, the fact may be intimated. Moreover, if the name is changed, administrative approval from PNAR may be furnished. 2, overage condonation may be obtained and recorded in the service book. Thereafter, my lord, annexure 4, page 11, relevant portion, may I read, my lord? In subclause 2, justification on how he was appointed overage with effect from 1/9/1999 in violation of PNAR OM number such and such, dated 4/8/1987, copy enclosed, and also the reason for delay of submission of proposal for condonation of overage appointment in violation of PNAR OM number such and such, dated 30th May 2017. My lord, again, running page 17, annexure 5. Relevant portion is,
Running page not 17, 12.
sorry,
12.
so running page 12, my lord. The relevant portion is in
Yes.
clause 2, I mean,
Second
Two.
paragraph. Yes.
he was appointed after he had crossed the permissible age limit prescribed by government for appointment due to exigency requirement of tailoring in the unit at that point of time. It is therefore requested that government may kindly examine the case and decide, please. Therefore, my lord,
Yes.
necessary party should be PNAR as well as the AG, because from AG, the,
Clarification has been sought for.
yes, my lord. So necessary parties,
AG
PNAR and AG may be included, my lord.
AG is not a party.
No, my lord.
What was the earlier round of litigation?
My lord.
What was the earlier round of litigation at page 13?
Of my
Yes.
affidavit, my lord.
No, page 13, he had filed earlier a writ petition. It was withdrawn. Next page. We are referring to page 12, the next page itself of your affidavit. WPC 178.
Yes, my lord. Yes, my
That
lord.
was withdrawn.
In view of the submission of the learned counsel, this writ petition is disposed of on withdrawal with leave granted to file afresh if need arises. Yes, my lord. So in order to dispense with justice, these two necessary parties may be included, my lord. PNAR and AG.
PNAR means?
Personal and administrative reform. Principal Secretary / Commissioner Secretary, PNAR.
And AG.
Yes, my lord.
Who are the parties here? AG is there, I think.
No, my lord.
AG is not here.
No, my lord.
Yes. Anything?
My lord, yes, I was in court.
Doesn't matter.
My lord, no doubt when the respondent is to have made state as necessary party, chief secretary, and then home commissioner, because we work under home commissioner, and then I'm directly appointed under DGP, so by DGP. My humble sub AG may not be a necessary party because they are objecting pension.
They are objecting your
It
worship.
is only processed by the state. State has to process that much.
No, see, Mr. Counsel, in your earlier writ petition, strangely, we find that AG was the party. If you come to page 13 of the affidavit in opposition, in the area of parties, Annexure 6.
Yes, my lord. As respondent number 4.
You on your own volition had made the AG a party. The role of AG appears to be a significant role.
No problem, no problem, no problem.
And for this small issues, I don't
No
think
problem. No
your substantial claim should not be defeated.
problem.
At least they're not defeated, you're entitled for a fair adjudication. On that will be a ground of adjudication, not going into the merits, that we are not very keen on having such a. You make the AG a party, will adjudicate if you are entitled to pension, then it will be an effective order also.
Yes, my lord. As well as PNAR.
But this matter is of which year? Or recent matter, but 23 is pending, you should have made the AG party. But the second question which will arise, yes, you have made an affidavit, executed an affidavit on 12/7/2002.
Correct.
You have changed your name from Janisol Angami to Devol to M. Birmani Singh.
Yes, my lord.
But how is how have you changed the name of your father?
Not father, himself.
No, father also. Janisol Angami is the son of Devol Angami, and Birmani Singh is the son of N. Krishna Mohan Singh.
Yes, my lord. Yes, my lord.
How does the name of the father
Entire.
change? Are you the same person? We are having serious doubts. You are entitled to change your name. But are you entitled to change the name of your father?
Religion.
These are issues which will come up tomorrow. So you better be prepared. Since you are getting a chance to file a fresh petition, or you intend to file IA or file a fresh petition? What do you intend?
My lord, if lordship permits me, I may be allowed to change in the cost title.
Then you have to file an IA.
Cost title in the cost.
You have to file an IA then. This changing by hand is not permissible nowadays because of the CIS system. You file an IA, we'll consider.
Just cost to change
Yes.
the cost. Otherwise, facts.
Okay.
And my lord, necessary two parties may be included.
Since you are getting a chance, yeah, add the personal and administrative reforms also.
Yes, madam.
I'll make PNR and
Yes,
AG.
yes,
as
yes,
necessary
yes,
party.
yes.
Respondent number 4 and 5.
We will not say anything in the order. We'll just record that his submission. That
I'll file it
necessary-
tomorrow. I'll file it tomorrow.
Whenever you file, okay. At the outset, an objection has been raised by the United State Council regarding non-joinder of necessary parties. And he has specifically made a submission that the Personnel and Administrative Reforms Department and the Accountant General Nagaland are necessary parties who, however, are not made respondents in this writ petition. Para. Learned counsel for the petition, sorry, learned counsel for the petitioner, prays for 2 days time to file appropriate IA for implement of parties. List matter accordingly stands adjourned to be listed along with the IA, if so filed, whenever filed.
For hearing item number 11.
May it please, Lord.
My lord, I have instruction of my client that we will allowed to withdraw the matter.
Will you withdraw this?
Yes. I'm for the petitioner, my lord.
Okay. Good that you are withdrawing. You are the sole tenderer. How could you give in the tender? Okay, doesn't matter. So we soon learned counsel for the petitioner submits that he has instructions not to press this writ petition. Also heard here for
1 and 2, respondent.
and madam. No, respond numbers 3 and 5. Please give your names. Who do not object to the said prayer, puts the para. Writ petition is accordingly dismissed on a trial. Okay.
Item number 12.
May I please, Lord?
Yes, please.
My lord, in this case, the other day on 7/5/2024, I sought the permission from the Supreme Court to file an additional affidavit. And we have prepared, but the client, he is from remote, little remote or Peck district. So we could not obtain. I may be allowed to file tomorrow. Affidavit is ready in fact.
Okay.
Just obtain signature and file tomorrow.
Okay. We'll have it on Monday next. Yes, anything?
No.
Okay.
No objection.
On the prayer made on behalf of the petitioner, further time is granted to file the additional affidavit. Full stop. List on Monday.
Operation.
Item number 13.
May I please, Your Lordship? Lordship, the petitioner here is praying for retirement benefits and pension. He was appointed as work judge Chukidar and retired on superannuation pension, superannuation after serving for 29 years, Lordship.
29 years you have served.
Lordship,
You're not getting the pension.
no, Lordship.
Yes, madam?
The petitioner was a work church employee, Lordship. And during his life, when he was in service, Your Lordship, for regularization, there is a particular OM 2004, dated 29/9/2004. This OM did not cover the petition, Your Lordship. For regularization of work charge employees, there were, it was based on seniority, Your Lordship. So he was not the senior most, Your Lordship, and.
No,
on-
this is only for the purpose of pension.
Lordship.
This is not for regularization for seniority. He has already retired from service. Are you disputing that he has served for 29 years?
And he was a work charge employee, Your
No,
Lordship,
are you
so
disputing
pension
that?
is not.
No, are you disputing that he served for 29 years?
That, no, Your Lordship.
Then there is a decision of Sanjita Roy. Have you got Sanjita Roy with you, madam?
No, Lordship. I have Pradeep Chakraborty in that regard.
Pradeep Chakraborty by which court?
The principal bench. Lordship.
Let us see. I think Sanjita Roy will directly cover your case.
Lordship, I was looking.
Yes, Sanjita Roy will try to have this case redressed.
Lordship, the relevant portion is at para 59, page 640. Lordship.
640.
Yes, 640. This distinguishes regularization for service as opposed to regularization for the purpose of
Pension, yes.
pension. Lordship. 59, Lordship, paragraph 59, if the Lordship has found it. Moreover, the past practice which has been referred to as one day.
Madam,
regularization-
you get hold of Sanjita Roy. That will help you. Okay, we can have it this any other day.
On Thursday, Your Lordship.
On
Thursday.
Thursday fix many matters. We can have it on Friday. Oh, this Thursday is a holiday. Friday is also a holiday. We can have it on Tuesday next.
Lordship.
Okay. Do you have the citation of Sanjita Roy?
I do not have it at the moment. Lordship.
It will be 2019.
Lordship.
2019, some GLT, GLR is reported everywhere. Okay. You can place this again on Tuesday.
Lordship.
Or let it remain in the file. We'll have a look. Paragraph?
Paragraph 59, Lordship.
It's belonging.
No, Lordship, I'm sorry. Paragraph
49.
59 and 63, Lordship.
Okay, we'll look into it. On a prayer made on behalf of the petitioner, a short accommodation is granted, directing listing of this matter. We can have it on Monday,
Your Lordship, Tuesday, Your Lordship. I'll have
Tuesday, okay, Tuesday, on Tuesday next.
much obliged, Your Lordship.
Item number 14.
1-4. Yes.
May it please, Lord. My Lord, in this matter also I instruction for withdrawing the matter.
Where are you doing all cases?
My Lord.
Not a very healthy sign for the bar if you're withdrawing all cases. Okay, same order. Huh? Please give your names. Item 11 of Procedural. Dismissed on required.
Item number 15.
One five, yes.
They agree by the letter canceling their candidature and also another letter canceling the offer of appointment to the post of CRPF, GT or constable CRPF. Now, I take your worship to the impugn order. The letter, first letter is 153, page 153. Your lordship.
153.
My lord.
How many of you are there?
6. This is a joint petition. 6 petitioners.
6 petitioners.
Your lordship. And clear copy, your lordship, 155. This is more clear.
You were Aspirants for CRPF constables.
Constable, Your Lordship, GD, general duty.
Page 155.
155, it's clear copy, Your
Okay,
Lordship.
okay. This is the call letter.
This is the, no, this is the offer of appointment,
Offer of appointment.
cancellation.
This is the offer.
No, cancellation of offer of appointment.
Cancellation or impugned order.
Your Lordship, the first impugned letter.
Okay. Yes, please. This is dated 15th of February.
Dated 24th of July.
No, 15th February 2021. You're at 155?
155, page 155.
This is 15th of February 2021.
No, Your Lordship. 155, this is 24th of July. 24/7/20. This is a letter issued by Office of DIG Group Center, Your Lordship. 155. Page 155, Your Lordship.
Of the petition.
There's a recast amended petition. There's a recast.
Oh, recast petition.
I'm sorry, Your Lordship.
No, doesn't matter.
There's a recast amended petition.
Yes,
Recast amended
Okay.
petition, Your Lordship.
Yes, we have got it.
If my lord may kindly come to page 155, this is clear copy.
This is the impugned order.
This is the impugned letter, Your Lordship.
Please read.
May I read? This is issued by the Office of the GIG Group Center CRPF Agartala. This is dated 24/7/2021, my lord. This is to Muakaba. He is the petitioner number 3.
Okay.
Now, subject is regarding cancellation of offer of appointment for the post of constable GD in CRPF.
This is P3 or P4?
Lord,
This is petitioner 3 or 4?
P3. P3.
P3.
P1 starts from 153. 153 is P1. 154 is P2. Similar letters were issued.
Understood.
Muakaba.
This is P3, this should be P3. Yeah, it should be written as P4. Okay. Please read.
You were selected provisionally for the post of constable GD in CRPF. Accordingly, you were issued offer of appointment by the office letter such and such, dated such and such, by this office with direction to report in this group center on 16/3/2021. On reporting, you had submitted all testimonials in original for documents verification and checking of your original documents, which were under process. In the meantime, case of district-wise mismatch cases were called for by our CRPF headquarters in consultation with Staff Selection Board. Accordingly, on checking of records, documents, it is found that your district of domicile Dimapur, which was mentioned in online application form, is not matching with your permanent residential certificate, PRC, in which your domicile district is Mokchung, as submitted by you. And as per direction of our CRPF headquarters, advertisement published notification issued for the subject post. In view of above, your case forwarded to CRPF headquarters for clarification. Thereafter, as per decision received from CRPF headquarters, your case was forwarded further to Staff Selection headquarters for revision of result of candidates whose data found mismatched, and now the direction have been received to return all such candidates back to their home till receipt of final decision from SCC on the subject matter. In view of the above, you are directed to return back to your home till receipt of decision from CRPF headquarters in this regard. The offer of appointment issued to you by this letter under reference is hereby cancelled. Now, similar letters were issued to all the 6 petitioners, Your Worship. And second impugned letter, Your Worship. Second 176.
Yes.
Second impugned letter, Your
Yes,
Worship.
please.
This is also by the same authority, Office of DIJ Group Center. This is dated 31/2023.
Yes.
31/2023.
Yes, got it.
Subject is regarding cancellation of offer of appointment for the post of Constable GD in CRPF. Please refer to office letter dated such and such. This is the first letter, 24/7. You were selected provisionally for the post of Constable GD in CRPF. Accordingly, you were issued offer of appointment by this office letter number such and such, with direction to report in this group center on or before 16/3/2021. On reporting, you have submitted all testimonials in original for verification of your documents.
Okay, we have read this.
The same, and then 3, para 3.
Yes.
Keeping in view the mismatch in documents.
Yes, we have read this.
Your candidature post is cancelled, Your Worship. Now, Your Worship, the issue involved in this, whether the mistake in the application form is a material defect affecting the eligibility criteria so as to penalize the petitioner by cancelling their candidature and also their offer of appointment to the post of constable, CRPF. That is the issue, Your Worship, whether it is a material defects, Your Worship. Now, coming to the facts, may I take Your Lordship to the advertisement?
Please.
Page 59.
59.
59. This advertisement. My Lord has got it?
Yes.
This is issued by Staff Selection Commission dated 21/7/2018, Your Lordship. Now, this is for, I'll just read this number F such and such. The Staff Selection Commission will conduct an open examination for recruitment to the post of Constable GD in BSF, CISF, CRPF. Now, Lordship may come to the last third line. Because this is related. The recruitment process will consist of computer-based examination, physical efficiency test, physical standard test, and medical examination. The salient feature of the recruitment are as under. Para 5, 6, and 7 are irrelevant, Your Worship. Para 5, Roman. Collection of required eligibility certificate/documents from the candidate and their verification will be carried out at the time of detailed medical examination, DME, by the CAPF. 6. Vacancies of Constable GD in NIA and SSF will be filled on all India basis, whereas vacancies in all other CAPF, Central Armed Police Force, will be filled as per the vacancies available in various states, union territories. In addition, vacancies are earmarked for the border guarding districts and militancy Naxal affected district, which are reserved for the candidate of those districts only. 7. The list containing names of border guarding district and militancy Naxal affected districts are available at Annexure 12 and 13. May I take Your Lordship to Annexure 12 and 13, which is at page 96. Page 96, Your Lordship, Annexure 12.
Yes.
My Lord has got it. Now, Annexure 12, this is a list of border guarding district. My Lord may kindly come to page 97, next page.
Mm. '97.
97, serial number 38,
Yes.
Nagaland is there, Your Worship.
Yes.
So in Nagaland, Peg is border guardian district. And respondent petitioner 4 and 5, they are from border guardian district, Your Lordship, 4 and 5. Petitioner 4 and 5.
Okay.
May I take Your Lordship next to page 100? Page 100 is Annexure 13, which is the list of militancy Naxal affected districts. Page 100. Annexure 13. My lord has got it?
Yes.
Now, page 100, the second last column, Nagaland is there, Your Lordship.
Yes.
My lord has got it. So in Nagaland, all district. So all district in Nagaland, in the state is militancy affected district, Your Lordship.
Yes.
Now, may I again take Your Lordship to the advertisement?
Yes.
Now, I've taken Your Lordship to page 59, now page 60. Page 60 of the advertisement, my lord.
Yes.
Now, para 2, it shows the vacancies and reservation. And note 3 at the bottom. Lordship, note 3 in bold, married. As the vacancies have been allotted to the concerned states, union territories, candidates are required to submit domicile permanent residential certificate of the state union territories indicated by them in the online application form at the time of DME, that is detailed medical examination, documents verification, failing which his or her candidature will be cancelled forthwith, and the candidate will not be allowed to appear in the DME. If a candidate produces domicile permanent residential certificate issued by a state other than the state mentioned in his or her application, he or she will not be allowed to change the state at the time of document verification, and his or her candidature shall be cancelled straight away, Your Lordship. So, in other words, Your Lordship, if it is issued by the same state, there is a discrepancy in domicile and PRC in the district. If it is from the same district, correction is allowed. But if it is from a different state, issued by a state other than the state mentioned, this is very relevant, Your Lordship, because I'm saying that the defect is not a material defect, Your Lordship. Here, only if it is issued by another state, then no correction. But if domicile and PRC district is issued by the same state, correction is permissible, Your Lordship. Now, vacancies, Your Lordship, is as per the state, Your Lordship. May I take Your Lordship to page 65? I will take on you to the relevant portion.
Yes.
65, para 8, Your Lordship. Para 8, the bottom, center of examination in bold.
Yes.
Now, center of examination, page 66, serial number 5. This is for Northeastern region. Page 66, serial number 5. Lordship has got it.
Yes.
Kohima is there, Your Lordship. Itanagar, Dibrugarh, Gauhati, Jorhat, Silchar, and Kohima is there, Your Lordship.
Yes.
Now, next, may I take Your Lordship to page 77. Page 77, para 11. Provides for the mode of selection. Lordship has got it. Now, this is a mode of selection. The recruitment process will consist of computer-based examination, PET, PST, and medical examination. All candidates whose online application are found to be in order will be called such and such. 3 computer-based examination will be held in this English. 4, the number of candidates shortlisted were paid such and such. So only candidates 5, only candidates who qualify in PET, physical exam, efficiency test and physical standard test, PST, and are shortlisted for DMA by the commission and whose documents are found to be in order will require appearing in the DME, which will be conducted as per revised uniform guideline for recruitment medical examination issued by such and such, dated such and such. The detailed medical examination issued by a what mandatory by nature. 6. Collection of required eligibility certificate documents from the candidate and their verification with original documents will be carried out at the time of detailed medical examination. All verification will be done by the CAPF, Central Armed Police Force, Your Worship. Now, last page 80. Page 80, para 15, Your Worship. Court's jurisdiction, Your Worship, para 15. Any dispute in regard to this requirement will be subject to court tribunals having jurisdiction over the place of concerned region, sub-regional office of the commission where the candidates appeared for the computer-based examination. Now, Your Worship, the petitioners that have appeared examination, CB here at Kohima. So this honorable court has jurisdiction, Your Worship. Now, my lord, in response to the advertisement, this notification, the petitioners have submitted the application and they were issued e-certificate, e-admission certificate. There is no dispute over the facts, Your Worship. It starts from 113, e-admission certificate.
No, you can address on the issue involved.
Yes.
These are not disputed.
These are
jurisdiction of court, however applied,
Lordship.
you being physically fit.
Lordship.
We address on the issue, the discrepancy of the place of domicile and your permanent address.
No, Your Worship. No dispute at all, Your Worship.
No, the dispute which appears from the impute order is a discrepancy in stating
domicile
your
district?
domicile district in the online address and later on
PRC.
Yes, PRC.
PRC.
Yes.
So, Your Lordship, now just may I take Your Lordship for a moment 127, just for your listing, 127.
Yes.
Now, this is the offer of appointment. After everything done,
127.
127. After everything done, they have passed in all the 3 tests: computer-based examination, physical standard test, and detailed medical examination. Thereafter, they were issued this offer of appointment. 127. The 15th February 2021. May I read, Your Lordship? As a result of successfully qualifying written examination for the post of constable GD exam such and such in as conducted by the SSC and completion of the recruitment process, you have been allotted for enlistment of CRPF. Accordingly, you are provisionally selected for appointment as constable general duty in CRPF. The post is purely temporary, but but likely to continue. Page 129, my lord. Page 129. The second para 4. If you accept the offer of appointment on the terms and conditions mentioned above, you should report for duty to the DIGP Group Center CRPF such and such, Your Lordship.
You also read at 129 serial number P, the first clause.
Lordship. In case you are found ineligible or supposing facts on any ground at any time before, during, or after selection process, whatever, everything is there, Your Lordship. Now, similar offer of appointment letter were issued to all the petitioners. Accordingly, Your Lordship, the petitioners, they have reported to the group center, and they were also assigned duties and force number, Your Lordship. They were assigned given force number. They were also assigned duties and responsibilities, Your Lordship. While discharging their duties, they were served with the first impugn letter.
Yes.
Your Lordship. Now, so, Your Lordship, the petitioner have submitted representation that it was not deliberate, not intentional, not intended, or not intended with the intention to get some undue advantage, whatever, Your Lordship. So, though they were to reconsider the case of the petitioner, Your Lordship. But then that was rejected, representation was rejected. Accordingly, Your Lordship, the petitioners have approached this honorable court, challenging the impugn letter, the first letter, and one of the ground for challenge was that was their offer of appointment was cancelled even before the final decision was taken by the competent authority. Because Your Lordship, may I take Your Lordship to the first impugned letter, 153. Clear copy is 155. The last line. Even second para is clear. In view of the above, you are directed to return back to your home till receipt of decision from CRPF. In fact, no final decision was taken. Before taking that final decision by SSC, competent authority, their offer of appointment was cancelled. Accordingly, the petitioner approached this honorable court, Your Lordship. And after about 18 months, after filing of this writ petition, Your Lordship, they have issued the second impugned letter, cancelling the candidature, Your Lordship. So, and that is why, Your Lordship, this amended writ petition, I have incorporated the subsequent impugned letter, Your Lordship. Okay. Now, my respectful submission, Your Lordship. As per the notification, the vacancies are statewise. Now, the PRC district and the domicile districts, Your Lordship, it is required for the purpose of identifying, firstly, whether the candidates, the petitioners, they belong to the particular states because the vacancies are statewise. Secondly, whether the candidates, they belong to militant border guarding district because there are additional vacancies earmarked for candidates who are from border guarding district. And the third, Your Lordship, is whether the candidates, they are from militancy affected district, militancy or Naxal affected district, because even for those two categories, there are additional vacancies earmarked for them, those candidates who are from those respective district, Your Lordship. It is not in dispute that the petitioners, the 6 petitioners, they are from the state of Nagaland. Now, and all district in Nagaland, Your Lordship, I've taken Your Lordship to NH, they are from militants affected district. And in fact, one of the district PEG to which the petitioner 4 and 5 belongs, they are from border guarding district. The additional vacancies are also there, Your Lordship. But unfortunately for petitioner number 4 and 5, they did not put PEG as the domicile district. And instead of getting that, deriving that additional benefit, they have deprived themselves. So in other words, it was not intentional. It not making mistake in putting the domicile district, in fact, proved to their disadvantage, Your Lordship. So question of getting undue benefit does not arise, Your Lordship. And as all the districts in Nagaland, Your Lordship, is declared as militancy affected district, Your Lordship, by the mismatch in district, be it in domicile district or PRC district, Your Lordship. The petitioner, they have not gained any advantage. Now, as per the notification, Your Lordship, they have now appointment selection process has to be as per the notification. Now, as per the notification, Your Lordship, paragraph page 59. May I take Your Lordship again to page 59?
Yes.
Paragraph 5. Collection of required eligibility certificate.
Yes.
Page 59,
Yes.
Roman 5, Your Lordship.
Yes.
Those are the salient feature. Collection of required eligibility certificate, documents from the candidate and their verification will be carried out at the time of detailed medical examination by the CRPF, Your Lordship. So at the time of detailed medical examination, Your Lordship, all the documents that were submitted by the petitioners, they were verified, Your Lordship. And the fact that they were allowed to participate in the DME, in the medical examination, speaks for itself that the mismatch in domicile district and the PRC district has nothing to do with the eligibility criteria. Because they are eligible because they all are from the state of Nagaland, and all districts in the states are militancy affected district, Your Lordship. Now, the union they have filed affidavit, Your Lordship. I'll take the 3 paragraph affidavit in opposition. Paragraph 15, 16, and 19 starts from page 13, affidavit in opposition. Page 13, Your Lordship. I'll just read 3 paragraphs. May I read out?
Yes.
That with regard to the statement made in para 13 of the petition, the answering deponent states that the petitioners here have mentioned incorrect district in the SSC online application form, which does not match with the indigenous inhabitant and PRC certificate. Keeping in view of the false information furnished in their application form and mismatch in domicile certificate PRC, their provisional appointment for the post of CD, Constable GD were rightly cancelled. 16, that with regards to the statement made in para 14 of the petition, the answering deponent state that the petitioners here have admitted the fact that they have filled the wrong domicile certificate in the application form. The following undertaking have also been given by the petitioners herein while filling the online application form. I hereby, this is part of the form, I hereby declare that all statements made in this application are true, complete, and correct to the best of the knowledge and belief. I understand that in the event of any information being found suppressed, false, or incorrect, or ineligibility being detected before or after the examination, my candidature appointment is liable to be cancelled. I am willing to serve anywhere in India. Hence, the action taken by the department regarding cancelling the provisional of the appointment letter is legal, valid, and in accordance with law. Para 19. That with regard to the statement made in para 19 and 20, it is submitted that SSC have already considered the case of the petitioner hearing and revised the result and declared the petitioner as not qualified on the ground of domicile mismatch, and in accordance with the said decision, the candidates of the petitions were cancelled and same has been informed to the petitioner. Now, the only ground taken, Worship, by the respondent is that we were found not qualified because of the mismatch in the domicile district and the PRC district, Your Worship. Now, they are not, all other facts are admitted. They are not denying that the vacancies are state-wise. They are not denying the fact that all district in the state of Nagaland is militancy affected district, Your Worship. And it is also not the case of the respondent that because of that mismatch.
After God, not to sleep like this. You have to sleep. You have to sleep. God. Ask him to go home and sleep.
And it is also not the case of the respondent, Your Lordship, that because of the mismatch in domicile district and the PRC district, Your Lordship, the petitioners they have often some undue advantage, Your Lordship. Now, as I've stated, Your Lordship, in case of petition number 4 and 5, by not putting PEG as the domicile district, that
That you have already submitted.
It proved to be to their disadvantage, Your Lordship. Now, so Your Lordship, that whatever mistake has been committed at the time of filling up the form, Your Lordship, it was not a material error, Your Lordship, in my respectful submission, Your Lordship. Therefore, the action of the respondent in cancelling the candidature of the petitioner on the ground of being not qualified is unfair and unjustified, Your Lordship.
Yes.
In support of my submission, Your Lordship, I may be allowed to refer
Yes,
from
please,
authorities,
please.
Your Lordship. The first case, Your Lordship, this is from 2024 SEC Online SC 22, Vishwas Narayan Kumar versus State of Bihar. This is a short judgment.
Paragraph?
Short judgment, Your Lordship. May I read the paragraphs, Your Lordship, the whole paragraphs, Your Lordship. But let me start from para 2. And Your Lordship's judgment
You
also.
read the operative part.
The operative part, Your Lordship. Now, okay. "15, Your Lordship, para 15.
Yes.
Recently, this bench in such and such, while declining relief to candidates who occurred eligible after the date mentioned in the notification cover a narrow exception. There, the judgment in such and such, a case very similar to the facts of the present case were noted. In Ajay such and such, now para 9. It is true that whenever any material discrepancy is noticed in the application form, and or when any suppression or misrepresentation is detected, the candidature might be cancelled even after the application has been processed and the candidate has been allowed to participate in the selection process. However, after a candidate has participated in the selection process, Your Worship, and cleared all the stages successfully, his candidature can only be cancelled after careful scrutiny of the gravity of the lapse and not for trivial omission or errors, Your Worship. Here, I have completed all three examination. I have been given offer of appointment. I have joined. I have been given force number. While performing the duty, the offer of appointment was cancelled, Your Worship. Now, para 27, Your Worship.
27.
27, the conclusion. Here, Your Worship, the mistake was in the date of birth. And Your Lordship, judgment also is there, Your Lordship.
27.
For the reasons stated, we set aside the judgment of the division bench of Patna High Court such and such, and direct the respondent to treat the applicant as a candidate who has passed in the selection process held under advertisement such and such, Your Lordship.
Yes.
And case law number 2, Your Lordship.
Yes.
This is passed by this honorable court, relying on the judgment passed by Your Lordship. Only 2 pages may I read out, Your Lordship.
You read your next 2544 of 2020, which has been relied upon.
Yes,
Where is that?
that is 4, case number 4, citation number 4. Yes.
Okay.
They passed by your lordship. Lordship has got it.
Yes.
This is the same advertisement, your lordship. And pertaining in respect to the same advertisement, your lordship, case law number 5. This by a division bench of the High Court of Bombay, your lordship. This is also same advertisement, your lordship. Now here, para 2.
Yes.
The earlier relates to date of birth. This one relates to domicile district, your lordship. Para 2. The learned counsel for the respondent relies on clause 17 of the SSC notification to contend that any mistake in mentioning the domicile district entails disqualification. The petitioner has only mentioned the domicile district in column 17 as Aurangabad, though he is domicile of Jalna, your lordship. Same advertisement, same notification, your lordship.
Then what was the decision of Bombay High Court?
And then
In this?
para 4. It is not disputed that petitions were not to gain by writing domicile as Aurangabad instead of Jalna. In column number 24 and 25, the petitioner has given postal address and permanent address as of district Jalna. It appears that in column number 17, the petitioner committed a bona fide mistake of mentioning district of domicile as Aurangabad. The petitioner's detailed medical examination was also conducted. It does not appear that petitioners had intention of misleading, nor would gain any advantage by mentioning district of domicile as Aurangabad, lordship. Now, next, your lordship, another same advertisement, citation number 6. This is from Andhra Pradesh High Court, your lordship. Now, read petition number 3537 of 2021. I have downloaded this from the portal, your lordship.
Name of the parties?
Name of the parties, your lordship. May I take your lordship to the last page here? Name of the parties is not there, but in the portal, there's the last page of the judgment or the order. Your lordship has got it. E-court.
Yes.
Yes. Now, name of the registration number, read petition number is there. Decision date is there. Case disposal. Name of the parties is Viramalu Aruna Venkateshwar Rao versus the Union of India Staff Selection Commission, Director General. The parties are the same, your lordship. Same respondents. Now, your lordship, since I have replaced reliance on the judgment order passed by another high court, your lordship, on that, my case law number 7, para 23. Is by Supreme.
What was the mistake in this Andhra Pradesh case?
Yes, Andhra Pradesh. This is also relating to domicile, your lordship.
Domicile,
lordship. Now, page 2, from 4th line, from 3rd line. It is further the case of the petitioner that the fifth respondent issued a rejection order dated such and such, declaring the petitioner as disqualified on the ground that the petitioner has wrongly mentioned the place of domicile district, your lordship. Now, and then, your lordship, since I have placed before your lordship some judgment passed by another high court, your lordship, on that case law number 7, your lordship, para 23. Last page. The second, para 23, second last line, your lordship. This operative portion, the judgment of the other high court, though not binding, have persuasive value on that, your lordship. We should be taken note of. That is the thing.
Yes.
So, your lordship, coming to my prayer at page 20, I read petition. Operative portion starts from page 21, Your Lordship.
Yes.
So I'm praying for question and satisfaction the impugn letter 24/7/2021, and also the impugn letter, both the impugn letter 28/11/2022.
These are common letters.
This, yes, to all, the same letter issue. Common, Your Worship. Separate letter, but then same dated same, Your Worship. So each separate letter we issue to all the petitioners. And then, yes.
Ideally, you ought to have filed separate petitions because the number letter dates are the same, the letters are different. Cause of action is analogous, no problem, but these are individual causes of action. Doesn't matter. At this stage, we may not be very strict on that point. Okay. That's all?
So, Lordship, so.
Yes, we'd like to have your response.
Obliged.
Yeah, for this central government.
Central ground consultation. Before I write my submission, Lordship, I may be allowed to read one paragraph from my affidavit in opposition.
Yes, please.
Page 6.
Page 6.
Page 6. My paragraph has already read out, but I want to read
Yes,
again.
yes.
Lordship, 6. It is also stated, Record Lordship.
Yes, yes.
It is also stated herein that while filing the online application form, the petitioners also given undertaking, the contents of which are as follows. I hereby declare that all statements made in this application are true, complete and correct, to the best of my knowledge and belief. I understand that in the event of any information being found suppressed, false, or incorrect, or ineligible, being detected before or after the examination, my candidature appointment is liable to be cancelled. I am willing to serve anywhere in India. Then, Lordship, that with regard to the statement made in para 1 and 2 of the writ petition, the answering deponent states that no right of the petitioners have been infringed. The candidature of the petitioners herein were rightly cancelled by the appropriate authority on the ground of strict mismatch. The petitioners have misled the department during the entire recruitment process and have also not come before this honorable court with clean hand. Hence, the petitioners have no legal standing to file the present writ petition before this honorable court, and the same is liable to be dismissed in Yemen without merit. The Lordship, their whole recruitment was dismissed because they have given false information. Now, if my Lordship may come to the writ petition, the recast writ petition.
Yes. Page?
Lordship may come to page 4.
4.
Page 4.
Yes, please.
The address, this is the course title.
Yes.
The petitioner number 1, Lordship.
Mm.
Petitioner number 1 is Sri Tongbimo Udio, age 38, son of so-and-so, house number 285, lower PWD, Kohima, Nagaland. But however, if my Lordship come to page number 7.
7.
Page number 7, Lordship, of the petition.
Yes.
7, para 3A. It is stated that he is presently residing at Oka district. In the course title, it says he is a resident of lower PWD, Kohima, Nagaland. But in the petition, he said he's a resident of Oka district. So also, Lordship, petition number 2. He said resident of Alichen, Mokokchong, Nagaland. Alichen, Mokokchong, Nagaland. But in page 7, 3A, says in the last 3B is presently residing in Oka. Yes, so it's all false information, Lordship. Then also come to petition number 6 at page number 5.
Page number,
Page number 5, petitioner number 6.
okay.
It says, Lipi Momo Zoe, age number so and so, son of so, Sanchon village, Dimabor, Nagaland.
Correct.
But in page 8, it says resident Ruchung village, Oka. So they are all this time they are giving false information. Lord. So that is why their candidature was not allowed and dismissed by giving false information. If my lordship may come back again to my affidavit in opposition.
Yes.
Yep. Page 7. Starting from para 5, lordship.
Page 7, you said?
Page 7, starting from para 5.
Yes.
May I, lordship?
Please.
That with regard to the 7 made in para 3A of the petition, the answering one stated, while filing up the online application form for the post of CDGD.
No, see, so far as your action is concerned, technically going, you are correct. There is discrepancy in the PRC district.
Yes.
And the domicile district.
Yes.
And Learned Counsel for the petitioners have also not tried to justify that there was no mistake. He has admitted that while stating the districts in the domicile and PRC, there are discrepancies. But whether the question from this court would be whether those discrepancies can be stated to be such that would go to the extent of holding them disqualified. You definitely have an undertaking.
But lordship, they have given an undertaking.
You definitely that is
in the writ petition. Even in the writ petition, they have some false residential address.
No, see, what has been stated in the writ petition so far as this matter is concerned, we will be more concentrating on the aspects which we have taken into consideration for declaring them to be unfit or rejecting their candidatures. You said that there is a discrepancy of their addresses, of their districts, domicile and PRC. We are going to examine that. You are at your liberty to point out, and you're right, in fact, that there is discrepancy even in this petition with regard to the districts shown in the area of parties and in paragraph 3. We have seen this, those. But those also would be relevant. But what is more relevant is to examine whether this discrepancy can be held to be so fatal that they should be disqualified from their entitlement for being.
Lordship, I
number
one. Are introduced in
number one. Number two, undertaking is there.
Yes.
That you cannot give a false statement. This statement, see, there is a difference, thin line of difference, as you know, between an incorrect statement and a false statement. The moment you bring in the element of false, the element of intention would come in. I am stating something which is false, means I am knowingly doing it with an intention to make a false representation. Now, to examine that, we have to see what is the consequence he is gaining. The fact that all the petitioners are inhabitants of the state of Nagaland is not in dispute.
No.
Nagaland is one of the states for which vacancies are there and recruitments are made. Learned Counsel is emphasizing on fake district for 4 and 5, that they could have got an additional advantage. We are not even going into that issue. We are on the broader issue that all the 6 petitioners, they belong to the state. And this recruitment was for the state. While mentioning the districts, there has been some discrepancies.
Yes.
But the districts are admittedly within the state of Nagaland, not in another district, another state.
Yes.
So that is that mistake, whether that mistake would be a ground strong enough to cancel their recruitment. If otherwise they are found to be fit in computer, then fitness, medical, what are the 4 components? You had said 4 components. One is
medical.
One is computer-based examination, one is physical examination test, one is physical standard test, and one is medical examination.
Yes, they have been found to be physically
Now,
proven.
only on that, don't you think that that's a trivial error which would have no consequence? Technically, yes, we are again repeating. Technically, our declaration which was given was not correct to their knowledge. There are discrepancies. And even in this petition, we have seen that correct projection has not been made. But will it have any significant change in the decision-making process? That is the question.
I'll leave it to your lordship.
No. We want your response, and you have done your best to. You have shown the undertaking. You have shown that even in the petition there has been discrepancies, and see, coming to the court with clean hands is cannot be with regard to the decision-making process. Coming to the court with clean hands would only confine to the statements made in the petition.
No.
Here it may not have such an impact. Yes, there are in paragraph 3 it's not matching that for only for that purpose. Otherwise, for a decision-making process, there is no non-disclosure in this petition. Petition they have disclosed everything. Clean hands writ petition equitable jurisdiction is only when you make a wrong projection or suppress facts within your knowledge or misrepresent facts.
As far as I know, lordship, this petitioner, they are all from Nagaland. They are all local.
Oh, yes.
But,
That you are not.
at first they have said
No,
that
you have been fair enough. You have been fair enough. You have not disputed their that they are from the state of Nagaland. The action of cancellation of the appointments of the petitioners as constables GD in the CRPF is the subject matter of dispute in this petition filed by 6 petitioners who have joined together, full stop. Initially, the petition was filed challenging an order dated 24/7/2021, by which even before a final decision was taken by the competent authority pending verification, the offer of appointment of the petitioners were cancelled, full stop. Subsequently, on issuance of the final cancellation order dated 30/1/2023, the writ petition was amended, and it is both the orders which are subject matter of challenge. Full stop. Para. Before going to the issue, please have your seat. Before going to the issue, which requires a determination, it would be convenient if the facts of the case are narrated in brief. Full stop. Para. The 6 petitioners are all indigenous residents of the state of Nagaland in various districts. Full stop. Pursuant to a recruitment process for the post of, for amongst others, the post of constables GD in the CRPF, the petitioners had offered their candidatures. Full stop. As per the advertisement, the selection process was based on 4 stages, namely computer-based examination, physical examination test within bracket PET, physical standard test within bracket PST, and medical examination. Full stop. on being successful in all the aspects, the petitioners were offered appointments on 15/2/2021, whereafter they had reported for the duties and they had reported and were assigned duties, full stop. The petitioners were also given force numbers, full stop. However, by the first impugned communication dated 24/7/2021 issued by the DIG, the offer of appointment was cancelled.
I'm sorry, Lord. This is signed by Commandant but issued by the Office of DIG, page 153.
Doesn't matter. Issued by the office of the DIG. The offer of appointment was cancelled on the ground that there were discrepancies in the district of domicile and the district of permanent residency. Though the latter indicated that further verification was being done, the offer of appointment was already cancelled. And since the representation filed by the petitioners were rejected, the writ petition was instituted. Full stop. Subsequently, the order dated 30/1/2023 was passed of final cancellation, and accordingly, as indicated above, the amended writ petition has been filed. Full stop. Para. I have heard Sri so-and-so learned counsel for the petitioner, whereas the respondents are represented by Sri so-and-so learned CGC. Full stop. Para. The learned counsel for the petitioner has submitted that the discrepancy, if any, is of trivial nature, which does not, in any manner give any advantage to the petitioners in the selection process. Full stop. It is submitted that in such a recruitment which involves a number of candidates, applications are required to be filled up online, in which some discrepancies of this nature is a normal practice, would not be an abnormal thing. Full stop. He has submitted that there is no dispute that the petitioners are all permanent residents, DNTS, of the state of Nagaland, for which the recruitment was also involved. Full stop. The learned counsel, by drawing the attention of the relevant documents, has also submitted that in the that special emphasis were made for border guarding districts and against serial numbers 38 to 42 pertaining to the state of Nagaland, fake district was also notified as one of the border guarding districts, full stop. He submits that the petitioner numbers 4 and 5 are indeed from fake district, and by not disclosing the said aspect, the said two petitioners have actually been in a disadvantageous position. Full stop. The learned counsel has also drawn the attention of this court to those states earmarked having militancy affected districts. And so far as the state of Nagaland is concerned, all the districts are stated to be militancy affected districts. Full stop. The learned counsel has also referred to note capital Roman 3 in the advertisement, whereby change of the domicile oblique permanent resident district can be changed only when those are issued by another state. Full stop. It is accordingly submitted that even a change in the domicile and permanent resident districts is not barred if an incumbent is from the same state. Full stop. Learned counsel has also drawn the attention of this court to clause 11 relating to the mode of selection and clause 15 regarding the jurisdictional aspects in case of any dispute. Full stop. By drawing the attention of this court to the affidavit in opposition filed on 27/9/2023, the learned counsel for the petitioners has emphasized that the discrepancy oblique error involved is not a material error which would go to the root of the selection process. Full stop. He submits that such error was liable to be overlooked, or at least a chance was to be given to the petitioners to rectify the same, which has not been given. Full stop. The learned counsel has also been critical of the impugned orders which have been passed without giving a proper opportunity to the petitioners of hearing. In support of his submission, reliance upon the following cases have been made. Number 1, 2024 SCC Online, SC 2, Vasisht Narayan Kumar. Number 2, order dated 5/2/2021 of this court in WPC 2544/2020, Abu Qasim, fourth, one letter, 2 and 3 named, fourth. Next, order dated 27/7/2020 of the Bombay High Court within bracket Division Bench in WPC 4761/2020. Rajesh Sominath Nilakha. Next. Order dated 27/4/2022 in WPC 3537/2021 of the Andhra Pradesh High Court, name Veeramallu Aruna. मिल जाएगा हाँ, full stop. Para. In the case of Vasisht Narayana Kumar, comma, the following observations have been made which would be relevant. Paragraph 15-16. Quote, no? In the case of Abu Qasim, comma, this court has held that trivial error in filling up of application for recruitment which did not give any undue advantage to the incumbent should not be a ground for rejection of their candidature. Full stop. The learned counsel for the petitioner has clarified that the aforesaid decision is on the same advertisement, same recruitment process. Next. The division bench of the Honorable Bombay High Court in the case of Rajesh Sominath Nikhala Supra was also dealing with the same recruitment process in which an almost analogous situation had arisen regarding the domicile of the incumbent. Full stop. The Honorable Bombay High Court had, however, quashed the order of disqualifying the incumbent in that case. Full stop. A similar view has been taken by the Honorable Andhra Pradesh High Court pertaining to the same recruitment process. Full stop. Para. With regard to the proposition that decisions of a different High Court can also be relied upon and has a persuasive value, comma, the learned counsel has placed reliance upon the decision of Pradeep J. Mehta versus so-and-so, reported in 2008, 14 SCC 283. Per contra, comma, Sri so-and-so learned CGC has submitted that the issue involved is not as projected by on behalf of the petitioners, but the real issue is whether correct facts were given in the application. Full stop. The learned counsel, learned CCC, by referring to the affidavit in opposition filed on 27/9/2023, comma, more particularly the averments made in paragraph 2 has submitted that the applications were also to be supported by an undertaking to give true, complete and correct information. Full stop. It is further stipulated in the undertaking that in case any information was found to be suppressed or false or incorrect or ineligibility being detected,
before the examination, comma, the candidature oblique appointment could be cancelled. Full stop. It is submitted that in view of such clear undertaking, comma, and the aspect of discrepancy being not disputed per se, comma, this no relief can be granted to the petitioners. Full stop. The learned CGC has also drawn the attention of this court to the first title of the present petition containing the address of the respective petitioners along with the pleadings made in paragraph 3 of the same, and has submitted that even in this writ petition, comma, there are discrepancies in disclosure in disclosing their respective addresses. Full stop. He has also raised the issue of not approaching a writ court, which is a court of equity, with clean hands. Full stop. The learned CGC has, however, fairly submitted that there is no dispute that all the petitioners are indigenous residents of the state of Nagaland. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court have been carefully examined. Full stop. Para. The facts noted above would boil down to the issue of a disclosure made in the application for recruitment submitted by the petitioners. Full stop. The rejection of the appointment vide the two orders dated 24/7/2021 and the final cancellation vide the order dated 30/1/2023 are on the ground that there are discrepancies in the addresses pertaining to the domicile and permanent residency. Full stop. The aforesaid discrepancy is not disputed. Full stop. What is therefore required to examine is whether the impugned orders are sustainable on the aforesaid ground. Full stop. Taking a very technical approach, comma, the impugned orders may not be found fault with, as there was also an undertaking in the application made by the candidates regarding their candidatures oblique appointment liable to be cancelled in case of incorrect oblique false information. Full stop. However, what is required to be seen is whether there has been any malicious intention on the part of the petitioners to gain undue advantage by making a disclosure which is not in conformity with the certificates given. Full stop. There is no doubt. There is no. It is not. There is no dispute in the bar that all the petitioners are permanent residents and indigenous people of the state of Nagaland. Full stop. This court has also noticed that in the advertisement, comma, so far as the state of Nagaland is concerned, all the districts are stated to be militancy affected districts where vacancies were to be filled up. Where recruitment were to be made.
Where, Your Lordship, additional vacancies.
Where additional vacancies were to be filled up. Full stop. This court has also been apprised, comma, as recorded above, that the petitioner numbers 4 and 5 who belong to the fake district and is one of the border guarding district had not disclosed that aspect which could have given them additional benefit. Full stop. Under those conditions, comma, it would be difficult to come to a conclusion that the discrepancy mentioned above would have a material bearing in the decision to hold, to doubt the eligibility of the petitioners for appointment. Full stop. Though the stand of the respondents is that a false statement has been made, comma, there is a thin line of distinction between a false statement and an incorrect statement. And to examine that aspect, comma, one has to see as to whether the incumbent had derived any advantage from such statement. Full stop. In the instant case, comma, paragraph. In the instant case, comma, this court has noticed that no advantage of any nature has been derived by such incorrect disclosure of facts. More so when it is not in dispute that all the petitioners are indigenous residents of the state of Nagaland. Full stop. Para. So far as the first impugned order dated 24/7/2021 is concerned, comma, this court is also of the view that when the entire matter was said to be under verification, comma, the cancellation could not have been made, and at best, such appointment could have been kept in abeyance, which was not done. Full stop. In any case, comma, this court is of the view that the action of cancellation, which has been communicated by the order dated 31/2023, is on an absolute trivial ground, which would not have any material bearing on the aspect of eligibility of the petitioners to be appointed as constables GD in the CRPF. Full stop. Para. The Honorable Supreme Court in the aforesaid, in the case of Vasis Narayan Kumar, has elaborately explained the aspect of trivial omissions or error. Full stop. This court has also been apprised that the decision of this court in the case of Abu Qasim and those of the Honorable Bombay High Court and Honorable Andhra Pradesh High Court are on the same recruitment process. Full stop. In fact, the cases before the Honorable Bombay High Court and the Honorable Andhra Pradesh High Court were on the same issue of domicile, which have been interfered by the honorable courts, and the appointments and the cancellation of appointments have been set aside. Full stop. Para. Considering all the aforesaid aspects and the discussions made above, this court is of the view that the impugned orders dated 24/7/2021 and 30/1/2023, by which the appointments of the petitioners have been cancelled, are unsustainable in law and accordingly set aside. Full stop. The petitioners are accordingly to be inducted back in their service as constables GD forthwith.
Unless some constitutional benefits.
When was the 21? It's not.
Anyway, March applies.
When were you appointed?
2021.
2021.
Oh.
2023.
Yes, it is further.
Mostly the
Only
cases was
only notional, nothing, not monetary benefits. It is further directed that the petitioners be given notional benefits, including seniority from the date of the initial appointment, but not, but such benefits would not be for any monetary consideration.
Obliged.
motion.
For hearing item number 16.
Yes. Yes.
Please, your lordship.
Item number?
16, your lordship. May I take a lordship to the affidavit filed on 15/4/2024 by the state respondents?
Yes.
This is an additional affidavit. But here, lordship, it is just in the subject index, it is written as affidavit in opposition. My lord, may I take a lordship to page 9, annexure B?
Of your petition?
No, of the additional affidavit.
Okay.
On the instruction and direction of this honorable court.
Page 9.
Page 9, your lordship,
Yes.
annexure B. This is a letter addressed to the government council, to Srimati Nohli Waza.
Yes, yes, we have seen this.
Yes, my lord.
Yes.
So, your lordship, the first para, my lord.
Yes.
Steps taken for constitution of the State Consumer Dispute Redressal Commission commence.
Yes.
The government has notified the Nagaland Consumer Protection Rules in the Gazette, copy enclosed. Number
Yes.
2, your lordship. Time to be taken for creation of post in the State Commission. This is the main contention before this honorable court. So, your lordship, the comment is time taken for creation of sanction of post in the Nagaland State Consumer Dispute Redressal Commission cannot be specified as the department has submitted proposal as per the Bagla committee report, and after obtaining clearance from the PNR department and concurrence from the finance department, the same is submitted to the Manpower Rationalization Committee, MRC, for further recommendation to be approved by the cabinet. So, your lordship, the very purpose of filing this writ petition is because there is not even a single post creation. All the employees who have served for more than 10 years, some are of course lesser than 10 years, your lordship.
You are in the State Consumer Forum.
There is a State Consumer Commission, your lordship.
Okay, you are employees with.
Yes, your lordship. We are the employees.
Okay.
There has not been a single post creation. And we have been working.
As an employee, what is your problem? What is the difficulty you are facing?
Your lordship, we have been serving for more than 10 years.
Not regularized.
But not regularized.
You want regularization of your service?
Yes, your lordship. But the post creation will have to be first, my lord is fully aware.
Posts are not created.
Posts have, not even a single post have been created.
So you have been inducted in the commission on what basis? On ad hoc basis or what? Exigency basis?
Yes, your lordship. We have been serving as a. My
So
lord,
madam, that commission is a permanent body. How can you run on an ad hoc manner? What has been projected is these petitioners, they are part of the commission, manning various facets of the commission. Now, this commission is not a temporary body that tomorrow it will not be there. It's going to be there.
Your lordship, not the members, they're the staffs, your lordship. And your lordship, if I may, your lordship, the prayer of the petitioner, your lordship, it's in there, with petition, your lordship, page 12, your lordship.
Page 12.
They're part-time employees, lordship, of the commission, your lordship.
no, your lordship, there is no such thing as part-time. The appointment order doesn't say so.
Some they are appointed on exigency basis, your lordship.
Page 12.
Yes, lordship. They-
Direct to create.
This is their prayer, lordship.
See, so far as the prayer number A is concerned, we may not be in a position to direct implementation of a report. But so far as B is concerned, their claim for regularization of the service, this may have to be considered by us. Whether they are able to make out a case or not, that's a different aspect. And if, as you have just pointed out, the appointment order at page 14, this is no doubt is for a period of 1 year. Okay?
Your lordship, page 21 as well, your lordship.
No, you
These
come
are-
to page 14,
14.
annexure 1 of the writ petition. 1/4.
Yes, your lordship.
You see that this is dated 30th of August 2011, right? This is for a period of 1 year. But what is the post about? Post is LDA come computer assistant. Initially, no post are there, no sanction post, so you give it for 1 year. But you are continuing. And when it comes to says that they are being continued from time to time, they are still continuing.
Then, my lord, the next page, page 15,
Yes.
that is, he was again temporarily assigned to the post of upper divisional assistant, upper division assistant.
No, it's okay.
Yes,
I'm
Lord.
just deciding this is also period for 1 year. But
Yes,
this
Lord.
1 year business is not going to stay for.
Yes, your lordship. And as per my additional affidavit, your lordship, the government is taking steps, your lordship. And we have all, now. there are-
What would be the outer limit by which you can take a decision?
Exactly, your lordship.
And your lordship,
This petition was filed when?
2022, your lordship.
20? Petition is of which year? 22.
This,
Almost more
yes,
than, almost 2 years have passed.
So your lordship, I mean.
13 June.
Almost 2 years. Are you considering the aspect? See, whether they get any substantial benefit, that's a different aspect.
Yes,
But at the same time, since they are working for more than 10 years, you have to consider that case. You cannot leave them just high and dry. Even if you go for a direct recruitment, some advantage has to be given to them, experience or something like that.
my lord.
Your lordship, with regard to the prayer, lordship, my submission is that as per the law laid down in
Uma Devi 3,
No, Ilmo Devi, your lordship.
Uma Devi.
No, your lordship, Ilmo Devi, your lordship.
Which one? What has been stated?
These two prayers will not be suspendable as per this judgment, your lordship. Your lordship, I may be allowed to read paragraph 8.4, your lordship.
8.4.
Yes.
Please.
Your lordship, the observation made in paragraph 9 are, your lordship, I may be allowed to read from 1, 2, 3. The third line, in any case, the fact remains that the respondents serve as part-time employees and were contingent paid staff. As observed above, there are no sanctioned posts in the post office in which the respondents were working. Therefore, the direction issued by the High Court in the impugned judgment and order are not permissible in judicial review under Article 226 of the Constitution. The High Court cannot, in exercise of the power under Article 226, issue amendments to direct the department to sanction and create the post. The High Court, in exercise of the power under Article 226 of the Constitution, also cannot direct the government or the department to formulate a particular regularization policy. Framing of any scheme is no function of the court and is the sole prerogative of the government. Even the creation or sanction of the
Madam,
post, Your Lordship.
there is absolutely no dispute. You cannot dispute with the proposition of the Honorable Supreme Court. But you have to examine the decision based on the facts. What were the facts involved in that case? In the case of Ilmo Devi, which had born from the state of Punjab and Haryana, these petitioners were contingent staff in the post office. They were Safai Karmacharis. They were additionally engaged. But here, it is the petitioners who are entirely running the show. They are not additional staff that without them you can run the Consumer Disputes Commission. They are the essential staff. And this commission being of permanent nature, you need to take some steps of sanctioning the post, filling upon regular vacancy. As we have already observed,
And
whether all the petitioners get the benefit or not, that's a different aspect.
Madam.
It can be considered, but Your Lordship, there also, the recruitment was also not done under spirit scheme of constitution, Your Lordship. So they cannot seek for regularization as a right, Your Lordship.
So it's not your stand that we'll fill up the post on regular basis by direct recruitment. That is also not your case.
So if the posts are sanctioned, Lord, the government might.
Now,
go for recruitment.
when was the commission constituted in Nagaland?
Your Lordship?
In the
It
state of
became
Nagaland?
functional in 2011, so.
2011 to 2024, you don't have sanction strength in Consumer Commission.
Yes.
That is not something very can be appreciated.
My lord is fully aware that my submission is also limited to the extent of whether the post can be created now. And the regularization, that's the next subject matter. And my lord, from what my lord has already said, I can understand that my lord is fully aware of the case of Narendra Kumar Tiwari, where in 2018, 8 SCC 238, para 7 to 10, my lord is aware that the Honorable Supreme Court has said that the mechanical application of Uma Devi in all the cases, when the state does what they want to do, at the end of the day, somebody has given their lifetime of service and then they be kicked out left and right just like that, my lord. That has been deprecated by the Honorable Supreme Court. So, my lord, here regularization is another issue, but the post creation, as my lord has rightly observed, how long will it take? The post creation must precede the raising the grievance of other grievances, my lord. So, state has to come with a concrete timeline on to what extent the time will be required for them to create the post, my lord, sanction the post.
Your Lordship, I may also like to take you to Consumer Protection Act, Your Lordship.
But unfortunately, this case, there is another case. Umadibi is by a larger bench. This case intends to almost read down Umadibi. Umadibi is by a larger bench.
Yes, my lord.
This is a two judges bench.
Very true, my lord. Even otherwise, your lordship, the circumstance of the case has to be understood. Yes.
See, so as a high court, we are bound to follow what is the law laid down by the Supreme Court.
My
And
lord.
if there is a larger bench, and this is a two judges bench which tries to read down Umadevi, that will be slightly difficult. See, if you see that going by strict interpretation of Umadevi, how it is to be explained has to be explained by at least a bench of coordinate strength, equal strength. There is in fact another case, very recent, in the same lines, trying to read down Umadevi.
My lord.
Because practically what you are submitting That appears to be a very practical issue and problem also. A person having the eligibility, but there is some problem with the three conditions laid down in 53. Umadibi paragraph 53, three conditions.
Yes,
You have to have the eligibility.
true.
The
Your Lord.
initial entry has to be by some process recognized by law, and your continuance should not be by any interim order from the court.
Yes, my lord.
Now, in spite of this, there may be some cases.
True, your lordship.
And working for 20 years. But can you just shut them out?
Yes, my lord. Even that UP Electricity Board case, the judgment pronounced by Honorable Justice Markanti Kaju also, my lord, with.
Madam, you,
Yes.
what is your additional affidavit? Let us see. What have you stated in your additional affidavit?
In, Your Lordship, para 9 is the,
Paragraph 9.
sorry, Your Lordship, in page 9, this is the answer to the query raised by the court.
Page
Your Lordship.
9.
Yes, Your Lordship. Annexure B, Your Lordship.
The letter which I have just read, my lord, they cannot specify the time on when they can create the post. It may take another 10 years, my lord.
When was the gadget? Gadget is of 2019.
Yes, my lord.
No, it's 2021.
Yeah, 2021, rules of 2021.
Rules of 2021. We're in 2024. Come. Madam, this page 9 communication is not enough. Especially the comments to question number 2. Time taken for creation of sanction post in the commission cannot be specified.
Your Lordship, the finance and the PNR, they've all given their approval. Now it's with the chairman of the Manpower Rationalization Committee, Your Lordship.
You take instructions. We'll have this, we'll grant you some time, 2 weeks time. You get better instructions than this. We'll
Regarding
record.
the time.
No, we'll grant you 2 weeks time, get updated instructions. Okay. And what the Manpower Rationalization Committee
It's at page 20, Your Lordship, the letter.
further recommended it. Heard 3 so and so, okay.
Well,
In the affidavit filed by the state respondents on 10/4/2024 pursuant to the order dated 7/3/2024, a communication dated 3/4/2024 has been annexed. Full stop. The relevant aspects of the said communication is quoted below. You page, put a flag for you. This kind of green flag. Page 9, additional affidavit annexure B. 1 and 2, up to here. The commission no, don't say commission. The Nagaland State Consumer Disputes Redressal Commission
my lord.
had started functioning sometime in the year
2011, my lord.
and it is really an unfortunate state of affairs that till now the essential post for manning and for operating the commission are yet to be sanctioned. Full stop. Consequently, comma, the ad hoc arrangement of appointment is continuing for more than a decade.
Lordship.
Full stop. Para. In the aforesaid communication, comma, a very vague position has been taken regarding uncertainty of the time for creation of sanctioned post. Full stop. The commission is a permanent body constituted under a statute, and therefore it is only inconceivable that the commission would function on an ad hoc manner. Full stop. The para in while in the communication dated 3/4/2024, comma, no certain time has been specified, comma, there are
Your Lordship,
indications that clearance from the P&AR department, comma, concurrence from the finance department, and the manpower rationalization committee would be required, which are to be approved by the cabinet. Full stop.
and even the letter dated 6 February 2024 is election. Lordship. So this is the latest one election.
Latest we have given, third, sixth,
Page 20, Your Lordship.
Six.
This is the letter which the government had written to the chairman.
Last page of that
yes,
affidavit. my lord.
that is 6 February, we are in April
Yes,
2024.
madam.
Information given to you. Full stop. Para. The aforesaid stand. No. This court is of the opinion that expeditious steps are to be taken for making the commission function and operate in the proper manner for which the regular appointments are to be made, which will definitely require sanctioning of the post.
Madam.
Full stop. Para. The matter is, this court accordingly grants 4 weeks further time to the learned state council to come up with concrete instructions
Madam.
with a definite time frame by which such post would be sanctioned and filled up. Full stop. On the next date, comma, this court will consider as to the rights of the petitioners for any privilege on the account of serving the commission for more than a decade
Madam.
and attaining sufficient experience in the field.
Lordship.
Your Lordship, if I may, Your Lordship, the additional affidavit was filed in the month of April, not 10, not October.
We have said April only. What date we have said? April we have said. No? 3rd April, we have said 3rd April.
Apologies.
Lordship, Lordship.
Item number 19.
May I please, my lord?
Yes.
My lord, before I make a submission in the instant case, I would like to take your lordship to item number 13, my lord.
13?
Yes, my lord.
Yes.
14, my lord, 14. My lord, there the petitioners withdrawn the petition. However, there is an interim, my lord. Interim order is there, my lord. So that order may be vacated, my lord.
In item 13?
14, my lord.
14 we have already withdrawn.
Yes, but there is an interim.
Interim order. Who has
Yes.
written 14? Please make a note, huh? 14 interim order.
My apology, my lord.
Interim order. Accordingly stands vacated huh? In item 14. Yes.
Yes,
19?
yes, ma'am.
You are in 19?
Yes, ma'am.
Okay.
I'm the petitioner.
Yeah.
My lord, the case of the petitioner is that the petitioner was appointed as workers labor in the year 1995, my lord, in the pay scale of 540 per month, my lord. And while in service, my lord, the petitioner was granted scale of pay in the year 2021, my lord.
Yes.
Yes, my lord. First, may I read the appointment order, my lord? The annex.
What is the issue?
The issue here is, my lord, I am praying for regularization of the petitioner and to grant pensioner benefits, my lord. I've served for 27 long years and I've retired from the service, my lord. My lord, here, annex here is page number 13. By which order I've been appointed, my lord. So.
Yes, what do you say? 27 years he has served.
27 years, yes, sir. Yes, I agree.
He is asking
But
for
then,
pension. You have retired from service.
Yes, my lord, after serving for more than 27 years, my lord.
He has
He was appointed, petitioner, your lordship petitioner was appointed in 1995. So 2001, he was given skill. So now.
Was he in regular service?
No.
Work church, my lord.
No, was his services regularized?
His service was not regularized.
Not regularized.
Not regularized. He was appointed as a fixed fee casual employee in 1995. After serving for 1995 to 2000 and during 2021, he was given the scale up pay. And right after giving the scale up pay in 2022, he was retired. That means in total, he has served the department for 27 years. That is the thing. We have a policy, your lordship, state has a policy framed in 2015. That is those work church employees who have served continuously in a scale up pay for 30 years can be regularized by converting their boss personal to them.
Right.
That is the only,
30 years.
30 years in a scale up pay. So additional regularization as per the standing memorandum of the state is not qualified. It's not qualified.
From the scale payment, how much years did he serve?
Petitioner was for 27 years.
No. From the grant of scale payment.
Little more than 1 year, my lord.
Oh?
Little more than 1 year.
1 year.
Yes, little more than 1 year.
He was.
My lord, I was.
No, if the policy does not cover you, under what, from where do you accrue your right?
My lord, I'm relying on the order passed by this honorable court, my lord.
Page?
I have annexed at page. Page number 18, annex E, my lord.
Yes.
Yes, my lord. Type copy. So, my lord, may I be allowed to read the relevant portion?
Yes.
Page number 19, my lord. Page 19, last part of my lord. Married, my lord?
Yes. Yes, we have seen this. How do you distinguish this?
This is a decision, your lordship, way back in 2013. It means even this 2015 policy was not formulated. This was passed way back in 2013. Now 2024.
Have you challenged the policy of 2015? That is not the part of challenge.
No, no, no.
See, if you're, see, there are decisions of our court, which is also affirmed by the division bench, wherein as a regular employee, the incumbents did not fulfill the 20 years of that required period. So what we had order directed is that while calculating these 20 years, you should take into account even those periods which he had served as on ad hoc or work charge basis, only to equate to a 20-year period. But here you are not even regularized at any point of time. Number one, you have a policy that even if you served on an ad hoc basis for 30 years, then you can be regularized. You don't fall within that, you don't fulfill the requirement of the office memorandum. So, and that office memorandum as such is not the subject matter of challenge. The order passed which you are relying upon is of a period prior to the framing of the policy in 2015. Under those conditions, it will be slightly difficult to grant you
My
relief.
Lord Chair, I'm also relying on the.
And in fact, there is a
order.
division bench of the principal bench. In case of Upendas, State of Assam was Upendas, Retail 45 of 2011, I think, or 2014, wherein it has been laid down that so far the period of service you are rendering, you'll get the minimum scale of pay, but you will not be entitled to any pensionary benefits.
My Lord Chair, I'm relying on one order passed by this Honorable Supreme Court.
Name?
Name. My Lord Chair, the State of Gujarat and others versus Dalsipai.
You have a copy?
Yes, my Lord. Merit, my Lord. It is unfortunate that the state continued to take the service of the respondent as an ad hoc for 3 years and thereafter now to contend that as the services rendered by the respondent are ad hoc, is not entitled to pensionary benefits. The state cannot be permitted to take the benefits of its own wrong to take the services continuously for 30 years.
This is not a ratio. This the regularization order was directed by the High Court because he was serving for 30 years.
Yes, ma'am.
Now, in view of the policy, office memorandum,
Yes.
can you really grant you the relief? Difficult. Unfortunate, but difficult. Where is the policy?
And also, my lord, there is also one notification notified by the state respondent way back in 2004, similar to 2015. However, in that notification,
let us see 2015 notification. Where is it?
Considered
Lordship,
as per the seniority.
Lordship, kindly see the counter affidavit filed by the state.
Yes, page.
Your Lordship, page 3.
Of the counter affidavit?
Page 3 first.
Yes.
Para 6, may I read, Your Lordship?
Yes.
That with regard to the statements made in paragraph 6 of the writ petition, the deponent respectfully states that the petitioner submitted representation dated 19/4/2022 for regularization under clause 1 of the OM here so and so, dated 17/03/2025. But he is not eligible under the cited clause. Lordship, you will be aware about this 17 March 2015 OM. As I said,
Where is it? Have you annexed?
Lordship, may kindly see this. Regularization of service, clause 1.
Yes.
So the representation of the petitioner was passing under OM, so it does not apply because he has served with a scale up for 1 year only.
The council will be difficult.
And your lordship.
Difficult to grant you relief. Otherwise, we have full sympathy, but we cannot go beyond the office memorandum. Please, right.
My lord, here, I would also like to rely on one judgment, my lord, passed in Bharti Chakraborty versus State Office, my lord. My lord, here, I don't have extra copy with me right now.
What is the citation?
Pratik Chakraborty versus State of Assam, my lord.
Justice Bhuya.
Justice, yes, my lord. Yes, ma'am. Married, my lord.
It was on the
This is,
content
my lord,
of-
this is recorded in 2014 1 GLT, my lord. 617.
No, that was there already. It was already fixed in the other case. With Chakraborty. 2000?
2014, volume 1, GLT 617. 607.
617?
7, my lord.
Pradeep Chakraborty.
Yes, my lord, versus State of Assam. And relevant portion is para 59. Para 59.
No, it was given to us. I think those are what. That was a copy and it went with the file. Oh, it went with the file. Okay. Okay. It's okay, bring it forward. It's okay, you can bring it. I'll just dictate. Okay.
Married, my lord.
No, we have read that.
And also, my lord, I would like to place another judgment. Reported in 1997, volume 2, GLT 209, my lord. In the case of State of Manipur and other versus KSH Ipopal Singh, my lord. And the relevant portion is at page para 11 and 12. Para 11 and 12. My lord, I have a copy of this. So may I?
Please.
Married, my lord. Para 11.
Para 11?
Yes, my lord. We are being disturbed that the petitioner were compelled to go on superannuation after putting in 28 and 29 years of service, respectively, without any pensionary and other retirement benefits. In a welfare state like ours, committed to a socialistic version of society, it is unconsignable that employer compels the employees to go on retirement without any retirement benefits after putting in 28 and 29 years of services on the pretext of contract services. It will be hit by equality means as clearly enshrined in Article 14 of the Constitution. The writ petitioner respondents have spent the entire youthful life to the service of the state, rendering valuable service to the state as an artist. It will be too cruel to allow them to go empty-handed when they are aged, old, and infirm and incapable of earning by themselves. It is common knowledge that government servants work for future security. The arguments that a writ petitioner accepted the appointment with the full knowledge of the terms and conditions laid down in contract and therefore their services cannot be regularized and they are not entitled pension and other retirement benefits would amount to exploitation of labor. Maybe the petitioner have knowing fully well the terms and conditions of contract accepted the employment because of compelling circumstances. State being a model employee are not permitted to use method of exploitation against the biggest section of society. My Lord Baratu 12. We unequivocally of the view that the term contract appointment must be terminable at some stage of services, but if contract appointment continue uninterrupted till the age of superannuation, as it happened in the case at hand, the character of the contract appointment automatically changes and the employee that be treated under the normal government service rules, entitling them pensionary benefits. In the instant case, the stand taken by the appellant government that the respondent were on contract services and therefore even if they retire on attaining the age of superannuation, they will not be entitled to pension and other retirement benefits is unacceptable. If they are on contract services, their services could have been terminated when they are still youthful and they could have gainfully employed in some other avocation, but then after using the entire services, drain out the energy, and when they are aged, old, and infirm and incapable of functioning, allowing them to go empty-handed is an invasion of mandate of Article 14 and 21. Right to live has been interpreted as the right to live without dignity, unless citizens have means of sustenance, rights to live with dignity will have no meaning. The contention of the value council for the appellant are therefore rejected and untenable in Roma.
What is the, you're trying to refer and rely upon the CCS pension rules?
Yes, ma'am.
What is it?
I got here.
May I take the motion to
Page 6.
Page 6, yes, ma'am. Page 6. This is the government of India's order under CCS pension. So, Mary, my lord. 1. Grant of pensionary benefits to temporary government employees retiring on superannuation.
Okay, we'll continue at 2 o'clock.
Yes, ma'am.
How many matters are there remaining? Three more matters. Yes.
I'd like to mention item number 7.
Mentioning at this stage, why? We're in the midst of hearing. Item 7, yes, what do you want?
Lordship, it's in admission, Lordship. The petitioner's counsel had mentioned it, but there was no order passed, I think, Lordship.
Okay. We want an adjournment.
Yes, Lordship, to file our reply, Lordship.
You're for the petitioner.
No, I'm appearing on behalf of the petitioner's counsel.
That doesn't matter. You're for the petitioner.
Lordship.
3 weeks further time is granted to the petitioner to file reply affidavit.
Complies, Lordship.
With item number 7.
Yes, my lord.
Yes.
My lord, page number 6.
Page number
of the petition, my lord.
6 of
6 of the main petition, my lord.
Of your petition?
Yes.
Yes, please.
My lord, para 8, my lord. Second part. And that is Government of India's order.
Yes, yes.
Grant of pensionary benefits to temporary government servants retiring on superannuation invalidation on completion of 20 years, now 10 years temporary service. 1. In terms of Rule 2 of the CCS Pension Rules 1972, a government servant, including civilian servant, government servant in defense services, appointed substantially to a civil service of post in pensionable establishment is eligible for the grant of pension and their retirement gratuity. A government servant who at the time of retirement from services does not hold a lien on a permanent pensionable post is not eligible for pension and death retirement gratuity, but is eligible for terminal gratuity under sub Rule 1 of Rule 10 or sub Rule 1 of Rule 11 of the CCS under bracket TS Rules 1965. The questions of grant of pension to government servant who retire after long years of service without being confirmed in any post having under consideration of the government. It has been decided that a government servant who in his retirement from service on attaining the age of superannuation or on is being declared to be permanently incapacitated for further government services by the appropriate government authority, medical authority, after he has rendered temporary service of not less than 20 years, now reduced to 10 years, shall be brought within the purview of CCS Pension Rule 1972, and the condition holding a pensionable post in a substantive capacity shall be dispensed in his case. Consequently, such government servant will be eligible for the grant of superannuation or invalid pension, death cum retirement gratuity and family pension in accordance with the provisions of the aforesaid rules. My lord, this is the order under CCS pension rule to 1972. The government of India has passed this order. my lord.
This order has been adopted by the Nagaland state?
Yes, my
Where?
My lord, I would like to refer, take your lordship to page number 19, my lord.
19.
Yes, my lord, there is my annex here. My lord. This is
19.
the submission made by the state respondent in earlier case, my lord. So page 19, first para married, my lord. It is
But
also-
unfortunately, this is the case prior to framing of the 15 OM.
Yes, my lord, yes,
The entire scenario has changed after the 15 OM.
yes, my lord. Oh, my lord, that OM 17/3/2015 is for the employees who are still in service, my lord. But they have already been retired.
When?
And I retired in the year 2022, my lord.
22.
Yes.
So
Yes,
it will be effective for
OM is
you.
not covered in my case. However, I'm praying for regularization at least a day before my retirement so as to receive.
No, it cannot be an isolated case. Facts may be hard, but we have to follow the law. OM is there. The virus of the OM was put to challenge in other cases. That has been
Yes.
upheld.
My lord, here, yeah, there are other cases where OM has been challenged, my lord.
Yes.
It's still pending before this one.
But that OM is still existing.
Yes. And my lord, with regard to the citation which I've relied upon earlier in the case of Partip Chakraborty was state of Assam, my lord. There, my lord, in the case of Partip
Just a
Chakraborty.
minute, just a minute, please.
Yes. And my lord, with regard to the CCS pension rule of 1972, even if the state respondent has adopted the policy by OM dated 17/3/2015, that will not divert the implication of that CCS pension rule. That still holds on. my lord. And where it says that it's eligible for pension. Employees are eligible for pensionary benefits who have served for 10 years, my lord. And I'm covered by that, my lord.
Yes, please have a seat. By means of this petition filed under Article 226 of the Constitution of India, the following prayers.
My lord, my apology.
Yes.
Earlier, I have submitted one judgment.
Yes.
So they have not given the paragraph. So may I give the paragraph?
Yes,
now?
yes. Yes.
In the case of.
You have given Pradeep Chakraborty.
Yes, my lord.
5963 you have given.
Yes, that, apart from that, I would like to.
State of Manipur you have given 11 and 12.
Yes.
And which
here
one?
in Chakraborty, my lord, I would like to further add some more paragraph, my lord.
Which paragraph?
Starting from 2, 11, 12, 19, 32, 36, 59, and 63, my lord.
2,
11, 12, 19, 32, 36, 59, and 63, my lord.
Okay.
Your Lordship, kindly appreciate the stand of the state also. Now the petitioner has served as a fixed pay casual employee for 26 years. After that, he was given skill. So altogether, he served the department for 27 years. For 27 years. Lordship, here is a 2-week call. Now, in order to regularize the petitioner, there has to be a clear vacancy. There has to be a vacant post. Because creation of post is banned in Nagaland. There is no creation of post. Now there has to be a clear vacancy in order to accommodate the petitioner. And so far as the 1972 pension rules has been concerned, Your Lordship, this pension rules is not applicable to the petitioner.
Which rules?
Pension rules.
CCS.
1972 is not applicable to the petitioner because at the threshold, Lordship may see application. Persons in casual and delegated employment. So since he was a casual for 27 years, Your Lordship may appreciate page 13, the appointment of the petitioner in the read petition.
Page?
Page 13 of the read petition. This is the first appointment order in 1995.
Yes.
The petitioner. And then upgradation is not from fixed pay to skill pay. You'll find Your Lordship in page 15 of the read petition.
Yes.
And Your Lordship, I'd like to, just before Your Lordship.
Where is the upgradation? Page?
No, not upgradation, Your Lordship. Page 15. Page 15 is the order, typed copy of the order.
Yes.
Typed copy of the order granting petitioner skill update.
To skill pay.
Skill pay. That is on 5th March 2021. And the petitioner was released, next page, page 16, was released from service on 14 January 2022 on superannuation. Next page, page 16. Lordship, this kind of matter has already been settled by this Honorable High Court, as well as by the Apex Court. Your Lordship may appreciate the Honorable Division Bench of this High Court in a similarly situated case has decided on 8/6/2023. And then Honorable Supreme Court has made a judgment on 11 July 2022. Lordship may appreciate this too.
Please.
The division order of the division bench is 18 page. 18 pages. But then here, the Apex Court order is 7 pages. If you allow Your Lordship to read the Apex Court judgment.
Yes, please.
May I read it, Your Lordship?
Please, please.
State of Nagaland and others versus Najibia Jumi judgment, MR Shah. Number 1, feeling aggrieved and dissatisfied with the immune judgment in order dated 19/4/2021 passed by the Honorable High Court of Gauhati at Kohima and read a bill 21 of 2019 by which the division bench of the High Court has dismissed the said appeal and has confirmed the judgment in order passed by the learned single judge directing the appellant state to regularize the service of the deceased husband of the respondent from 1 day earlier to his death and thereafter to pay family pension to the respondent. The state has preferred this present appeal. Number two, the deceased husband of the respondent was working as work judge to collect. Same as the present petitioner, Your Lordship.
Yes.
He died in harness on 28/8/2005 as a work judge employee. That in the year 2017 and after a period of 12 years from the date of the deceased employee, the respondent herein, the widow, wife of the deceased employee, filed a writ petition before the learned single judge claiming that the services of her late husband ought to have been regularized and therefore she is entitled to family pension. The learned single judge allowed the said petition and directed the appellant, the state, to regularize his service from 1 day prior to the date of his demise, so that the respondent herein, original writ petitioner, and her family members are entitled to pensionary benefits. Feeling aggrieved and dissatisfied with the judgment and order passed by the single judge, the appellant, the state, has preferred the appeal before the division bench of the High Court. By the impugned judgment and order, the division bench of the High Court has dismissed the said appeal and has not interfered with the judgment and order passed by the learned single judge regularizing the service of the respondent's husband 1 day prior to his demise. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by the division bench of the High Court and not interfering with the judgment and order passed by the learned single judge, the state has preferred the present appeal. Though served, nobody appears on behalf of the respondent. Mrs. K. Enna Tulisema, learned counsel appearing on behalf of the state, has vehemently submitted that the impugned judgment and order passed by the High Court directing the appellant state to regularize the service of the deceased employee 1 day prior to his demise is absolutely unsubstantiable. She has made the following submissions. Number one, that during his lifetime, the deceased employee never claimed regularization. That the respondent, original petitioner, widow, claimed regularization after a period of 12 years from the date of the deceased employee. Number three, even otherwise, the deceased employee was not entitled to regularization, even on the date of his death, as he was much below in the seniority list, and his turn had not come for regularization. Learned counsel, on appearing on behalf of the state, has further submitted that, assuming that the service of the work judge employee were required to be regularized, in that case, also, as per the scheme, the services of the work judge employee were to be regularized as per seniority and as in when vacancy arises. It is submitted that all those work judge employees whose service were regularized was much after the date of the deceased employee, and that too as per the seniority. It is submitted that therefore, at the time of the date of the deceased employee, he was much below in the seniority list, and therefore his services were not required to be regularized as his turn has not come. It is submitted that therefore the High Court has.
You read the finding. Why are you reading the submissions? Read the finding of the court.
No, I am continuing, Your Lordship.
These are submissions. Submissions you can skip. You can.
No. I'm coming to that, Your Lordship. It is submitted that therefore the High Court has committed a grave error in directing the appellant to regularize the service of the appellant 1 day prior to his death. Making the above submission, it is better to allow the present appeal. Having heard the counsel, operative para I am coming, Your Lordship.
Yes, please.
Having heard the counsel for the state and considering the submission made on behalf of the state, and having gone through the judgment order passed by the learned single judge confirmed by the division bench, we are of the firm opinion that the High Court has committed a grave error in directing the appellant to regularize the service of the deceased employee 1 day prior to his death. It is required to be noted that the deceased employee died in the year 2005. During his lifetime, he never claimed for any regularization. The respondent herein, originally petitioner, wife of the deceased employee, claimed the regularization of the period of 12 years from the date of the deceased employee. At the time of the date of the deceased employee was not entitled to regularization as he was much below in the list of the work judge employee whose service were to be regularized. Under the regularization policy, the service of the work judge employee are required to be regularized as per the seniority and as and when the vacancy arises. The service of the other work judge employees even who were senior to the deceased employee were regularized in the year 2009, that is, after the date of the deceased employee. Despite the above, the High Court has directed the state to regularize the service of the deceased employee 1 day prior to his death, which otherwise his service were not required to be regularized as his turn has not come and he was much below in the seniority list. Considering the aforesaid facts and circumstances, the impugned judgment and order passed by the High Court is unsubstantiable and the same deserves to be quashed and set aside. In view of the above, and for the reasons stated above, the bill is allowed. The impugned judgment and order passed by the division bench of the High Court as well as the learned single judge is hereby set aside, is hereby quashed and set aside. Consequently, the original writ petition filed by the respondent herein stands dismissed. Lordship, Your Lordship may kindly come to state counter, Your Lordship. State counter page 5. Page 5 is the Nagaland Work Charge and Casual Employees Regulation Act 2001. This is the act which governs the work charge. Page 5, Your
Of your
Lordship.
affidavit of opposition.
Affidavit in opposition of the state.
Yes.
Page 5.
Yes.
This is the regulation. The title is the Nagaland Work Charge and Casual Employees Regulation Act 2001. This regulation covers all the employees, work charge, casual employees. Your Lordship may kindly turn to page 6.
Page 6, yes.
Page 6. Here is the definition. Casual employee. Casual employee means an employment engaged without sanction post. Number T, work charge employee means an employee engaged without sanction post under work charge establishment. So the petitioner is in that category. As I said, Your Lordship, first petitioner has to be regularized. Only that the question of his pensionary benefits will come. Lordship, that is my respectful submission before Your Lordship.
My lord, here the ruling which the state respondent council has relied upon is entirely different facts and circumstances, my lord. The first judgment which the Honorable Supreme Court has passed an order, that is entirely different. Why? Because there the respondent has prayed for posthumous regularization, my lord. That is one count. And second is that the respondent has approached the court after 12 years. So on that ground also, the petition was allowed, which was filed by the state respondent before the Honorable Supreme Court. So here, the entire facts and circumstances are very different. And now the second judgment which he has relied upon is that order is under review, still pending before the Supreme Court.
Which one?
The order which has been passed by this honorable court, by the division bench, where my learned friend has relied upon. So that is under review, my lord.
Under?
So review, my lord.
Review?
Yes.
Is there any stay?
I'm not aware, my lord. No, my lord, there is no stay.
And this is a division bench.
Yes, division.
Be binding upon us.
Pending before this one.
We are not aware that this is a division bench. Initially, the single judge's order was in favor of the incumbent.
Yes, ma'am.
The appeal was by the state.
Yes.
Okay. What did we write? We have a sit, have a sit. Have been prayed for, okay? Yeah, anything you want to say?
No, no.
Please have a sit.
Review, division bench review, I agree. It's under review. Council is here.
With the following, you give the prayer, okay? Here at page 10 and 11 of the writ petition. The facts projected in the writ petition are that the petitioner was appointed as semi-scale labor in the establishment of the executive engineer, public health engineering department, within bracket PHED, in the year 1995. Full stop. He was upgraded as work charge Khalasi on 5/3/2021 with a scale of pay. Full stop. The petitioner has retired from service on attaining the age of superannuation on 30/6/2022. Full stop. The claim of the petitioner, as would be evident from the relief prayed for, is towards regularization of his service so that he gets the benefit of post-retirement. Full stop. Para. I have heard Sri So-and-so Learned Counsel for the petitioner, whereas Sri So-and-so Learned State Counsel is present for all the respondents. Full stop. The Learned Counsel for the petitioner has submitted that the petitioner has served for a long period of about 27 years, and he cannot be left without any pensionary benefits after such a long period of time. Full stop. The action of the respondent authorities in granting the petitioner pay scale on and from 5/3/2021 has also been highlighted. Full stop. Para. The Learned Counsel has referred to Rule 2 of the Central Services within bracket pension bracket close rules 1972 and has contended that in view of such rules which only contemplated 20 years of service, which has presently been made 10 years for being entitled to pensionary benefits, the petitioner should be granted such benefits. Full stop. The filing of the representation by the petitioner, which has not been considered, has also been highlighted by the Learned Counsel for the petitioner. Full stop. Para. In support of his submission, the petitioner has relied upon and in fact annexed a copy of an order dated 8/7/2013 of this court passed in WPC 213K 2012. Give the name, huh? Page 18A. So and so versus State of Nagaland. Full stop. It is submitted that in the said case, comma, a similarly situated person was given the benefit of regularization of his service so as to be entitled to pensionary benefits. Full stop. The court had also relied upon an earlier judgment of this court reported in 1997 2 GLT 209 State of Manipur and others versus KSH Ibobal. Full stop. In the case in the case of KSH Ibobal, comma, the petitioners were found to be serving for 28 and 29 years without any pensionary benefits, and accordingly, comma, the directions were passed for giving them the benefit of regularization of their service and consequent entitlement to pension. Full stop. Sarah, the Learned Council has also relied upon the case of Pradeep Chakraborty versus State of Assam, reported in 2014 1 GLT 617. Full stop. In the said case, comma, this court had directed giving the benefit of regularization of work charged and master roll employees engaged prior to 1/4/1993 in the state of Assam so as to be entitled for pensionary benefits. Full stop. Reliance has also been made on the case of Bobal, we have already stated. Per contra, comma, the United States Council has submitted that though it is not in dispute regarding the total length of service of the petitioner, which is about 27 years, comma, the out of the said service, comma, the petitioner has served in fixed pay for 26 years and he was only granted scale pay on 5/3/2021 and he had retired after about a year thereafter on 30/6/2022. Full stop. it is submitted that to affect any regularization, comma, there has to be a post oblique vacancy, and that presently there are no vacancies in the state, full stop. There is also, it is contended, don't say there is also contended. It is contended that creation of post is also banned in the state of Nagaland. Full stop. He has submitted that the Central Service within bracket pension rules of 1972 do not have any application. Full stop. Para. The State Council has also placed on record an office memorandum dated 17/3/2015, as per which a policy decision has been taken for regularizing service of existing work charged and casual employees who have completed 30 years or more continuous service as on 1/1/2015. Full stop. He submits that under the said office memorandum, comma, not comma, which is in operation, comma, the petitioner is not entitled to
Your
for
Worship,
regularization.
It should be enjoying scalar pay also, scalar pay.
Regularization. Full stop. He clarifies that the grant of scale payment for 1 year will not entitle the petitioner to seek the benefit under the OM dated 17/3/2015, which stipulates minimum 30 years of continuous service.
With scalar pay. With scalar pay, enjoying scalar pay.
Who were enjoying scale pay.
Scale pay.
The learned council, state council, has also relied upon a decision of the Honorable Supreme Court dated reported in AIR 2021 SC 4855. Name Union of India versus Ilmo Devi, in which the Honorable Supreme Court has passed, has rendered a caveat upon the High Courts not to issue directions for regularization and similar benefits unless the employees concerned had entered into the service by following the due process of law. Full stop. Reliance has also been made upon a judgment of the Honorable Supreme Court dated 11th July 2022 in civil appeal number 4223 of 2022, State of Nagaland versus Nichevi Achumi. Full stop. It is submitted that the said appeal was against the decision of this court, which was also affirmed by the division bench, pertaining to regularization and consequent direction for payment of pension. Full stop. The Honorable Supreme Court has, however, interfered with the aforesaid direction by holding that the decisions of this court towards regularization and pension were not in accordance with law. Full stop. Para, the United States Council has finally submitted that the issue in question can be put to rest by a judgment and order dated 8/6/2023, passed by a division bench of this court in WA 27/2022. Full stop. In the said case, the Honorable Division Bench had held that the rules of 1972 would not be applicable to casual and daily rated employment, and accordingly, the claim for regularization and consequent pension have been rejected. Full stop. Para. The learned counsel for the petitioner in his rejoinder has submitted that the decision of the division bench in the case of in WA 27/2022 is presently under review. Full stop. He has also submitted that the decision of the Honorable Supreme Court in the case of Nichevi Achumi is distinguishable on facts, as the aspect of delay of 12 years was also one of the consideration. Full stop. Para. The rival submissions have been duly considered. Para. The present claim is towards regularization of the service of the petitioner and consequent pension. Full stop. It is not in dispute that the petitioner had served on fixed payment for about 26 years out of his total 27 years of service, and the last about 1 year, he was given skill payment. Full stop. Be that as it may, the petitioner does not fulfill the requirement of completing 30 years or more service in skill pay as per the office memorandum dated 17/3/2015. Full stop. The judgments relied upon by the petitioner is of a period prior to coming into operation the office memorandum dated 17/3/2015. Full stop. It is also not the case of the petitioner or any of the parties that the vires public legality of the office memorandum is under challenge or has been held to be unconstitutional by any judicial pronouncements. Full stop. Para. Apart from the case laws of the Honorable Supreme Court placed on record, relied upon by the learned counsel for the respondent, what is to be noted is the decision rendered by the Honorable Division Bench on an issue which is exactly similar to that of the present case. Full stop. The Honorable Division Bench in clear terms has held that the rules of 1972 would not be applicable, and therefore the prayer for regularization and consequent entitlement for pension cannot be entertained. Full stop. Though the aforesaid judgment and order dated 8/6/2023 is said to be under review, this court is bound by the said ruling of the Honorable Division Bench. Full stop. Para. In view of the aforesaid discussion, this court is of the considered opinion that no relief can be granted to the petitioner, and accordingly, the writ petition is dismissed. There are no orders to post.
For hearing item number 20.
What is it? Yes, madam. Item number
20, my lord.
20, yes.
My lord, here the petitioner was appointed as contingency sweeper in a fixed pay.
Okay, what is your prayer?
My lord, here my praise for granting minimum scale of pay.
Minimum scale of pay.
Yes, my lord. As per.
How many years are you serving?
My lord, for 15 years.
15 years.
Yes, my lord.
You are relying upon Upendas. Which
lord.
you are relying upon the case of Upendas.
No, my lord.
Which one?
My lord, the case of state of Punjab and others versus Jagjit Singh and others.
No, that has been considered. And where is the Upendas? State of Assam versus state Upendas. It's reported. Bring it, it will help you. But that was upon a concession made by the state of Assam. It may not be binding on the other states. A concession was given. They are seeking regularization. The division bench has said that you are not entitled to regularization. But since you are serving for more than 10 years, you will be entitled to the minimum skill payment. But that was upon the concession made by the state. That will grant them minimum skill. That concession we cannot bind the other state of Nagaland unless you say something. What is your take?
Your Lordship, in absence of any policy of the state, because granting of scale up pay, there is no policy. It's a discretion of the department concerned. The state only they used to grant the skill. See, by looking into the merits of the works of the petitioner. Now, Your Lordship may kindly appreciate this notification. Lordship, not only the petitioner, but we have many cases before this court for seeking for granting of scale up pay. That is why state has formulated this notification and a committee was being constituted, Your Lordship.
Right. You examine her case?
Once certain policy has been framed by this committee, which is a high-level state committee, which includes representatives from the Department of Law and Justice, Finance, Home, Personnel, and Administrative Reforms Department.
It is the committee is only meant to frame the policy.
It has to frame the policy and come up with a
policy will have to be adopted by the state. If at all some policy has been suggested, cabinet has to approve. Then only your case may be considered, madam.
My lord, as per Article 141, my lord, clearly provides that the law declared by the Supreme Court should be binding on all.
Under Article?
Article 141.
Oh yes, which law? That, but it depends on the policy. Let us see what is the law laid down by the Supreme Court. Please.
My lord, the relevant portion is in page number 99.
Yes,
At para 54.
yes.
My lord, kindly allow me to read the further. Para 54. There is no room for any doubt that the principle of equal pay for equal work has emerged from an interpretation of different provisions of the Constitution. The principle has been expounded through a large number of judgments rendered by this court, and it constitutes law declared by this court. The same is binding on all these courts in India under Article 141 of the Constitution of India. Paragraph 57, having traversed the legal parameters with reference to the application of the principle of equal pay for equal work in relation to temporary employees, under bracket, daily wage employees, ad hoc employees, employees appointed on casual basis, contractual employees, and the like. The sole factor that requires our determination is whether the concerned employees before this court were rendering similar duties and responsibilities as were being discharged by the regular employees holding the same responding post. This exercise would require the application of the parameters of the principle of equal pay for equal work summarized by us in paragraph 42 above. However, insofar as the instant aspect of the matter is concerned, it is not difficult for us to record the factual position. We say so because it was fairly acknowledged by the learned counsel representing the state of Punjab that all the temporary employees in the present bunch of appeals were appointed against posts which were also available in the regular cadre establishment. It was also accepted that during the course of the employment, the concerned temporary employees were being randomly disputed to discharge duties and responsibilities, which at some point in time were assigned to regular employees. Likewise, regular employees holding substantive posts, which also posted to discharge the same work, which was assigned to temporary employees from time to time. There is, therefore, no room for any doubt that the duties and responsibilities discharged by the temporary employees in the present set of appeals were the same as were being discharged by regular employees. It is not the case of appellants that the respondent employees did not possess the qualifications prescribed for appointment on regular basis. Furthermore, it is not the case of the state that any of the temporary employees would not be entitled to pay parity on any of the principles summarized by us in paragraph 42 herein. There can be no doubt that the principle of equal pay for equal work would be applicable to all the concerned temporary employees so as to vest in them the right to claim wages at par with the minimum of the pay scale of regularly engaged employment employees holding the same post. In view of the position expressed by us in the foregoing paragraph, we have no hesitation in holding that all the concerned temporary employees in the present bunch of cases would be entitled to draw wages at the minimum of the pay scale extended to regular employees holding the same post. My lord, and even in my affidavit reply.
Yes, what do you say, State Council, on this?
Your Lordship,
Jagjit Singh?
the coordinated bench of this Honorable High Court, a similar case was filed by All Nagaland Vitality Fair Workers Association.
Okay.
So it was on 9/4/2024. Lordship, may beruse this.
Please.
Same matter, grant of skill up.
Are you aware, madam, of this matter?
Lordship, operating para you will find in page 4. The last page, your Lordship, para 6.
Jagdish
May I
Singh,
read your lordship?
Jagdish Singh was taken into consideration. Jagdish Singh state of Punjab was taken into consideration in this case.
It was not considered.
It was considered.
It was not considered. Jagdish Singh case was not considered.
Why not considered? Paragraph 3, because that
No, that is the submission of the petitioner.
no, that was considered. Considered doesn't mean following. That was discussed.
That was discussed.
Discussed and differentiated. That is what we are
Yes.
meaning.
My lord, a similar case in. with
Just
equal-
paragraph 6, you are
This is the operative portion of the order.
by dispose of direct in the committee consideration. This is not against you, madams. This is only directed the committee which has been constituted to expeditiously frame the policy and take care of the cases. It will be covered by this judgment. We'll follow this judgment. This is neither in favor of the state. In fact, it is in your favor, but it is not directly in your favor. It is only directed the committee to expeditiously move the things. Okay, we'll dispose this of in terms of. You can have a look. Just have a look. This decision. A short point is involved in this writ petition. Full stop. The facts projected are that the petitioner was appointed as a contingency sweeper in fixed pay in via an office order dated 22/1/2009 in the establishment of the Sub-District Industries Center, PEREN, PEREN, in the state of Nagaland. Full stop. The petitioner has been representing for grant of minimum scale of pay, and in this regard, comma, our representation dated 19/4/2022 submitted to the director, comma, Industries and Commerce has been placed on record. Full stop. As the said claim was not considered, comma, the petitioner had approached this court earlier by filing WPC 98/2022, which was disposed of by this court wide order dated 6/6/2022, directing for consideration and disposal of the representation. Full stop. Subsequently, comma, wide the impugned letter dated 36/2022, comma, no, subsequently, wide the impugned letter dated 6/8/2022 issued by the director, comma, Industries and Commerce, pursuant to the letter dated 36/2022 of the Finance Department, comma, the petitioner has been conveyed that there is no provision for grant of scale of pay to a fixed paid employee. Full stop. Para. I have heard, Miss, you're Jillian. What is your name?
Mr. Christina.
It was, and Sri Learned State Council. Full stop. Para. The Learned Council for the petitioner has submitted that the nature of duties performed by the petitioner is similar to the other permanent employees in the state post, and therefore there should not be any disparity in the pay. Full stop. Reliance has also been placed upon the case of the Honorable Supreme Court, reported in 2017 within bracket 1 GLT within bracket SC 47. Full stop. Para. The London State Council has, however, informed this court that to take care of matters of the present nature, a committee has been constituted, wide notification dated 16/2/2024, to suggest a suitable policy relating to remuneration and terms of service of contingency and fixed paid employees. Full stop. The Learned State Council has also placed on record an order dated 9/4/2024 passed by this court in WPC 49 of 2023, whereby a direction has been given to expeditiously suggest the suitable policies by the committee constituted wide notification dated 16/2/2024 within a reasonable time. Full stop. Para. Upon hearing and taking into consideration the notification dated 16/2/2024 and the order dated 9/4/2024 of this court in WPC 49 of 2023, this court is in humble agreement with the directions, with the aforesaid directions of this court. Full stop. This court would, however, like to add that the period should be not more than 4 months from the date of certified copy, from the date of furnishing a certified copy of this order, so as for the committee to suggest the suitable policy in accordance with the objective of the notification dated 16/2/2024. Writ petition accordingly stands disposed of. The notification dated 16/2/2024 is made part of the records. You can take this back, madam. That's it.
Population.
From the supplementary list for hearing item number 27.
Is do rather than
14 years, 11 months. We like pray for the whole country because we have not completed 2 years. So the question is the government, we are typically that there is a good discharge. It is a resolution that is what we are trying to do. But I will be allowed to page 4 of the petition. Or the result that is was by overdated, then 576. When it was transferred to third entity, the supplement was in the first NAP to Kohima, then transferred to third NAP battalion Pension, is from Pension.
Okay.
Then what happens that para petition. What happened is this. After serving for so many days, the petitioner pushed up with notification or the judge due to his father's illness. His father was the head Kangura of the village, which is a hereditary statutory body in state of now. However, the discharge application is mentioned about. But the fact remains that in order to discharge that hereditary as well as statutory body under the government,
Now, what is the minimum period of service required?
one of the 10 years.
10 years?
Yes, that is under pension rule 49(2).
Is it 10 years or 20 years?
One of the voluntary retirement is 20 years. In that eventuality, what will happen is that he will get full pension. That is up to 33 years of service, as if he completed the service. But when it is below that, who have completed 10 years, it will be only proportionate to what he was given. 50% of what he was exactly given under.
The discharge was on your own volition. You had
My lord, I approached the appointed authority. Yes.
so it will amount to a resignation of service.
My lord, I applied for discharge. That is, for what reason? The reason is to serve in a statutory body of the state government. Of course, there is no pension scheme there. The Kangura, which is a recognized statutory body in the state of Nagaland. That is, this is rules for the administration of justice imposed in the Nagaland District 1937. Chapter 2 is police. Rule 2.
The police of the Nakai Hills shall consist of regular police subject to Act 5 of 1861, that is Police Act, in the Assam Rifles Act of 1920. Then, that is A in Clause B, rural police consisting of Musadars.
No, it is okay. Gampuras are civil post. That we know.
Madam.
No, but we are not on what post you have joined after being discharged. You saw discharge on your own.
No.
That and you said that you have not completed 20 years, but you have completed more than 10 years.
10 years.
And where is it? Show us the law that if you have completed 10 years, you are still entitled. Show us the law.
Rule 49
Of
1972 rules, pension rules.
Pension rules.
I will be allowed to read out now. Yes. Page 121.
121, okay.
Yes.
Yes, please.
Amount of pension. Suppose one is in case of a government servant retiring in accordance with the provision of these rules before completing qualifying service of 10 years. The amount of service gratuity is the rate of half months cumulative for every completed 6 monthly period of qualifying service. So if somebody have not completed 10 years, yes, gratuity will be entitled. 2, subject to the provision.
That will be gratuity, amount of service gratuity. That is not pension.
No. If I do not complete 10 years, no. Gratuity, I'll be entitled. Even taking the words we automated, I have not completed 10 years.
Then also you will get gratuity.
No.
And if you have completed more than 10 years, then?
Then, subject to the provided sub-law, law 30, that is invalid pension, in the case of a government servant retiring in accordance with the provision of these laws, after completing qualifying service of not less than 10 years. The amount of pension shall be calculated if 50% of the emoluments or average emoluments, whichever is more beneficial to him, subject to a minimum of such and such. Then 2A.
Yes.
2A is not applicable in my case. Then the 4 is the minimum motive. Since somebody is not completed 10 years, what will happen? The amount of pension finally determined under sub-rule 2, because minimum is given this month. Then what will be the condition? Shall be expressed in whole be in where the pension such and such shall be rounded up to such and such. So, my lord, and relying on rule 5, chapter 2, that is page 7 of your lordship book.
Yes, 7, yes.
General conditions. Rule 5, declaration of claim of pension or family pension. Sub-rule 1, any claim to pension or family pension shall be declared by the provision of these rules, enforced in at the time when the government servant retired or is discharged. Take the words below the meter, discharged. Or is allowed to resign. Take it, either one. Because I was discharged by the appointing of,
or take it that I'm allowed to resign from service or dies as the case may be. So that is the rule permitted.
Okay. What is your case? You have served for how many years?
14 years, 11 months, 3 days.
14 years,
Yes,
11 months,
3 days.
3 days.
Yes.
Okay. So you should come under 49 too.
No, that is
More than
not
10
okay.
years,
In
50%.
yes, what he was exactly hitting at in that particular point of time. No addition. In rule 5, take it that I resign. Rule 5 permissive, allowed to resign. And my learned accountant general, he filed a affidavit. Whether when somebody have resigned, they are entitled. They are saying that they are not entitled, whereas the rule is very clear. So I filed a reply to that. That is just yesterday, 25/2024. In an earlier case, they've interpreted the law. That is my additional affidavit in reply, para 2. This is exactly the stance of the accountant general.
Yes.
2. As per CC's pension rules, minimum qualifying service required for pension is 10 years.
Yes. Yes, okay. We have seen this.
Cannot take the opposite stand now.
Yes, yes.
Yes,
Yeah, for the AG.
My lord.
We'll come back. Yes. For the AG.
In fact, Lordship, we have not filed an affidavit as far as the case is concerned, because this is an issue between
It
the
was a query from this.
petitioner and the state respondent.
Yes.
Now, Lordship, during the course of hearing, the court has directed the EG to file on 2 points, Lordship. Lordship, Lordship, may kindly come to my affidavit, Lordship.
You have filed affidavit?
Yes, Lordship. Respondent number 6.
R6, yes.
Yes, Lordship. No, Lordship, Lordship, may kindly see the order dated 5/10/2023. There was a direction from this honorable court on regarding 2 queries, Lordship.
Just a minute, please.
5/10/2023, Lordship.
Pass 8/11/2023, you have filed affidavit.
Yes, Lordship.
8/11. Yes, what are your answers?
The query number 1 is whether a government servant who has been voluntarily discharged from service at his own request after serving for more than 10 years is entitled to pension and benefit. 1, Lordship. Number 2, whether discharge from service and resignation from service is one and the same in regard to entitlement of pension. Now, Lordship, in this regard, I've sought for the answer from the Office of the Accountant General, Lordship.
Yes.
Now, Lordship, may kindly come to Annexure A, page 4.
Yes.
Of my affidavit. Lordship, the query is on next page, Lordship,
Yes.
page
Yes.
5. First query, Lordship. Whether a government servant who has voluntarily discharged from service at his own request after serving for more than 10 years is entitled to pension and benefit. A government servant who has, the replies, Lordship.
Yes.
A government servant who has been discharged, resigned from service on public interest is entitled to pension and benefit. However, an employee can voluntarily go on retirement after completing 20 years of qualifying service, CCS pension rules, that is Rule 43, 2021. Those government servants who quit resign, discharge from service at his own request is not entitled for pensionary benefits. So this is a query number one, Lordship. So this is a reply from the AG office, Lordship. Now, query number two, whether a discharge from service and resignation from service is one and the same in regard to entitlement of pension. So the reply, Lordship, given by the Office of the Accountant General is, in the case of civil government servant, the term discharge and resignation from service are treated as same in both the terms pensionary benefit will be entitled if it is in public interest. However, there will be no pensionary benefit if the government servant discharged resign on his own request. Now, this is the query that has been replied to, given by the Office of the Accountant General, Lordship. Now, Lordship, coming back to the writ petition, because the query was put up, Lordship, basing on the document of the petitioner, Lordship. Lordship, may kindly come to page 43, annexure 3 of the writ petition, Lordship.
Yes.
This is the discharge certificate, Lordship. Page 43A is the type copy, Lordship. He applied for discharge from service, Lordship. His discharge application is at page 42. Page 42 is his application, Lordship. Lordship, may kindly come to page 42, Lordship, yes. 42A is the type copy, Lordship. Subject, discharge from service. Lordship, this is where the court put up the query. On his own, Lordship. On his own. And the reason given is in the application because of his father's illness, Lordship. That's if I may be allowed to read the application, Lordship. To the Commandant, 3rd NAP Battalion, NAP, Tuinsang, Nagaland, through proper channel. Subject, discharge from service. Sir, I have the honor to state the following few lines for your kind consideration and necessary action, please. That's since so-and-so, it's not readable, Lordship. Till today, I'm serving under your kind command with so-and-so, but so-and-so, due to some unavoidable circumstances that my father is in old age and there's nobody to look after him. Therefore, I earnestly request you to kindly discharge me from service as domestic problem, for which act of kindness I shall ever remain grateful to you. Now, this is the application of the petitioner, Lordship. Now, Lordship, may kindly come to page 43A, the type copy, the discharge certificate. Now, Lordship, all these details are entered, Lordship. Date of entitlement, reasons for discharge. That no entry has been made. But the fact remains, he applied for discharge, so he has been discharged from service on his own. So as for the court, Lordship, because of this document, Lordship, moreover, it was incomplete, Lordship, because the reason for discharge was not mentioned. So this Honorable Court deemed it fit for some query from the Office of the Accountant General, Lordship. So that's how these two queries were put up to us, Lordship, to which we have replied. So what the Office of the Accountant General is saying is that when a person has voluntarily, on his own, asked for discharge, it is more or less a resignation from the post. So he'll not be entitled for pension.
But one thing, Mr. Counsel.
Lordship.
No, not to you. For the petitioner. Your discharge is dated 16/11/1994. Correct?
I got discharged from 1st April 1994.
1994.
So this is a certificate.
No.
Subsequently,
94, and you come to this court when? In 2021. Why this delay?
I've stated clearly that the petitioner is from a backward tribe.
Backward tribe will not make you delay of 20 and 25 years. This is an afterthought.
My lord, in the petitioners attended only up to class 3. That's it, the situation.
No, just now you were saying that he was discharging his duties with a disciplined force. He was a constable. Then he had gone to be a Gauhati.
Yes.
He is taking serious responsibilities. Education and formal education is a different matter. You are not aware of your rights. You're not espousing your rights. 94, you come to the court in 2021.
My lord, yes, I understand.
Have you made any explanation?
My lord, if your lordship deem it fit that it cannot go beyond to that level, but let the Darshan principle be applied.
No. Have you made any statements? Why the delay?
Yes.
We are not asking you to file separate application, but here in this writ petition, what were we doing from 1994?
My lord. Paragraph 1. That in spite of taking duty charge from completion of the pension service benefit one petitioner assets through help of valuation as the petitioner in later. Petitioner applied on 23/4/2019 to the apply for payment of pension retirement benefit. However, by June, they will sign that.
And where is the explanation?
But paragraph
Paragraph 4 is not the explanation. It's not an explanation. You submitted your representation in the year 2019.
No.
After 24 years.
I mean, we are not to submit that. When somebody have earned a certain benefit after serving a certain period of time, which is as per the rule.
No, that explanation also been given in on affidavit. That particular query has been answered.
No.
And that query, the answer is in consonance with the reasons contained in the impugned letter of 27 July 2021.
No, what I'm saying is, when resignation or you call it discharge, it is permitted by the rules. Rule 5. And when it is entitled as per Rule 49(2).
See, tell us one thing. Can you voluntarily retire before you complete 20 years, expecting some post-retirement benefits? You cannot.
No.
You are eligible to voluntarily retire to be entitled for post-retirement only after completion of 20 years. Otherwise, anybody can serve for 5-6 years, retire, get everything.
You are entitled for gratuity. 5-6 years. Who have not completed 10 years, they are entitled for gratuity. As per the rule 49(1). So we just say that the petitioner have not approved in time. But the rule is very clear. Thinking that he is not completed 10 years, still he will be entitled for gratuity as per the rule.
Yes, what about the gratuity part? What about the gratuity part?
Lordship, but those queries were not put up to us, Lordship. So I don't have any instruction on that, Lordship.
Now, if he is entitled to gratuity, though it's a case of
Lordship, state has filed a detailed affidavit to that
case
effect.
of absolute delay, but still then
Yes.
it's a case of pension also. So
Lordship,
we may
yes.
have some.
No, Lordship, as far as that gratuity is concerned, Lordship, state will be in a better position to explain, Lordship.
Yes, madam.
Because they have their.
The qualifying years will not matter, Lordship, because he has resigned and his past service has already been fortified, Lordship. Therefore, no pension can be granted to the
No,
petitioner.
we're not a question of pension. We are the question of gratuity. Pension, your submission is acceptable, that the past services gets erased. But gratuity, I think you should take instructions on the gratuity part.
Yes.
If he is entitled Otherwise, you are not too keen in entertaining this petition on the ground of delay. But at the same time, subject matter is pension. So we will take a balanced approach. Take instructions on the gratuity.
Gratuity.
Okay. The present application, present writ application is with regard to a claim for pension and other retirement benefits. Full stop. While the petitioner relies upon Rule 49, read with Rule 5 of the pension rules, 1972, comma, the respondents have relied upon Rule 26. Full stop. And this, the Accountant General, State of Nagaland, has also filed an affidavit answering the specific queries raised by the court, justifying the action not to release the pensionary benefits. Full stop. Para. This court has, however, noticed that the post-retirement benefits also includes the aspect of gratuity. And as per Rule 49(1), for period served which is less than 10 years, there is a provision for payment of gratuity. Full stop. Sarah? Let instructions be taken by the London State Council on this aspect and as to whether the petitioner, under the facts and circumstances of the present case, would be entitled for such a consideration. Full stop. When can you come back, madam?
Your Lordship, after 3 weeks, Your Lordship.
3 weeks.
Yes, Your Lordship, because they have to.
We thought by next week, then we could have decided
Okay,
this
Your Lordship, I will try make an attempt on Thursday, Your Lordship.
next Thursday. On request, list on Thursday next. Full stop. Depending on the instructions, this court would consider the matter. If you need more time, I'll grant you time. Don't
Yes, Your
worry.
Lordship, I'll make an effort. Your Lordship.
Okay, thank you.